Who appears for petitioner? Mr. Chittaranjan Patnaik. And what he give the file. What are the meaning from honorable suggestions?
I will.
Aligning the matter to me or anything else there. That's the reason. Okay, then yes. Homestead land means what?
Homestead. That is meant for houses.
Okay, non-agricultural.
House and the proper land attached to the embedded with the house. It is homestead.
Okay.
Civil revision petition.
If ex parte judgment in decree or set aside, what is the remedy in your state? Anybody good in CPC?
My lords, Order 9, Rule 13.
If it is allowed,
Yes.
against that appeal is maintainable or revision is maintainable?
It has to be revision.
It has to be revision only.
Yes, sir.
115 revision.
Yes.
For that it is nomenclature as CRP.
ये तो अभी पढ़े नहीं
Read Order 43, Rule 1. Do 6.
It is not an appealable order.
Not available. Not enlisted under Order 43, Rule 1.
No, your lord.
It is interpretation.
This 14-year petition seeks to lay a challenge to the order dated 30/6/2011 passed on respondents IA number 173 of 2010, whereby ex parte judgment and decree entered in CS number 125 of 2007-1. Ex parte judgment decree dated 11/10/2007. Have been set at naught. First, neither petitioner, call out name of the petitioner, court officer, call out name of the petitioner. Loudly.
Nirupama Rao.
Nirupama Rahul.
Thrice.
Nirupama Rahul.
Call out name of the lawyer.
Chittaranjan Patnaik. Mrs. Chittaranjan Patnaik. Mrs. Chittaranjan Patnaik.
Whatever it is. And degree have been said. Neither petitioners are present before the court, nor their counsel. First, the court officer on the instruction of this court loudly called out names of the petitioners and their counsel thrice. First, there is no response. First, in the above circumstance, it can be safely assumed that the petitioners are no longer interested in prosecuting the petition, and therefore the same is liable to be and accordingly dismissed for non-prosecution. The registry to send a copy of this order to the OPs. What you call them? OPs or respondents?
My lords, here petition,
No. Opposite party. What you call them?
opposite.
Opposite party by the speed post. So petitioners and the respondent OPs by speed post immediately. Okay.
Item 2.
One more sentence. The registry to send a copy of this order to the learned judge, the court below, for information and needful action. Okay. Yes.
Item 2.
My lord, I am for the petitioner in item 2. My lord, it's for removal of defects.
Yes. 2 weeks for removal of defects, peremptorily granted, failing which all these petitions stand dismissed. Next.
Item 3.
My lord, also item 3.
All right,
for the
3,
petition.
4, same. Next.
Obliged to Lordship.
For I am appearing,
Huh.
it may be, I think it may be ignored because this writ petition has been filed for fundamental right to have speedy trial. So the WPC I have rightly,
Right. 3.
and when the office pointed out the default, I filed that petition, that WPCRL, but I think that is WPC only it will be. Because for 15 years one,
Matter is pending.
yes,
You
in the
want
trial
the-
court, that is my last paragraph.
ST case number.
Yes, that is because they are in
Who
holding.
are you? Who are you then?
I am the informant because
You are the informant.
yes,
FIR is lodged by you.
okay, timely the informant has been murdered. Then who has given deposition? He has been murdered. The father who has seen the occurrence, he has been murdered. And the informant has been examined in this case, who is the son of that informant Sitapati Naik. For 15 more than 20 years, the case is going on.
You are son of the complainant, son
Yes.
of the first
Yes,
informant.
yes. I
No, what's your?
am having the order sheet, how it is done. The court is.
I am asking a question. You are
Yes.
answer. You are not the informant.
Yes. Several criminal cases have been filed. In one case, I am the informant. My father has been murdered for as informant in the case.
In which?
Then I was the informant in my father's murder case.
No.
Yes.
that-
First para I have
One
mentioned.
second. You have to look at the judge.
Yes.
You have to look at the judge so that you will satisfy the requirement of the court.
Yes.
In which case you are the informant?
Eyewitness to GR case number 36 of 2007.
But that is not the subject matter of this petition.
Yes, ma'am.
Then what do you?
ST case number pending in the court of law and ADJ Aska, connection with murder of one Surendra
That's
Naik.
all right. You have said it, so many murders have happened, we agree.
Yes.
The question is, that case in which you happen to be the first informant is
Yes.
not before the court.
I am the paragraph 4 I mentioned that the petitioner being an eyewitness to his father's murder, that is in GR case number 712 of 2007, ST case number 1 by 2011, the petitioner was falsely implicated in the case and was arrested and now has been released on bail in ST case number 21 of 13, living in a state of fearness
keep
by
your
hiding
prayer.
himself from place to place.
Madam, there is no communication. There is a lot of communication gap between the court and the counsel.
Yes, I do.
Read your prayer.
Yes. Place to place on the apprehending of being murdered like his father. Now,
Prayer.
prayer. It is therefore prayed that the Honorable Court may graciously be pleased to admit this writ petition in this session of mandamus, calling upon the opposite parties to show cause, and if the opposite parties fail to show cause or show insufficient cause, the said rule be made absolute directive hearing of the case in ST case number 51 of 2014,
One second. In 51 of 2014,
pending in the
are you an informant?
ASCA and ST case number 1 of arising out of GR case number so pending in the court of additional session judge Bhanjanath. Yes, my father was murdered. I was an eyewitness.
I'm asking you.
Then I am the informant.
Counsel for the petitioner is not
Yes.
answering the questions of the court.
My lord, my lord.
Repeated.
I may be permitted to, my lord.
You are not
because-
answering the court. This is a writ court.
Yes,
This is not an appeal court. We are asking you, are you the informant in the cases, namely ST case number 51 of 2014, ST case number 2 of 2009, ST
ma'am.
case number 3 of 2009, 7 of 2009, or GRC 7112 of 2007.
in that 51 2014, I am the informant. My father's death.
In 50. No,
51 by
of them is-
2014.
One second. You want all these cases are before the same court.
Yes.
One second.
That is,
Kindly answer my question. Kindly appreciate my question. Then you may try to answer.
I have mentioned two courts. One is ST case number, one is pending in the court of additional session judge Bhanjanagar, another is before the
Other
ASCA.
court.
ASCA.
There are other court.
Only to lessen the burden on the client. For all
you
the
can't.
two cases, persons are same, that accused are same, so that I have filed.
Madam, for each case, separate petition to be filed. Because each respondent will be different. Their stand may be different. We do not know. That is the reason.
That
officer
51 maybe that.
You will confine it to 51.
Yes, then another case I will file for another.
Petition prayer reads as under. You want early
Only
trial of that case.
yes, that order can be passed, that will solve.
That. Next paragraph. Learned counsel for the petitioner is confining the case, confining the prayer to ST case number 51 bar 2014 that is allegedly pending on the file of learned additional session judge ASCA.
ASCA.
First of counsel submits that right to speedy justice is one of the facets of Article 21 of the Constitution of India in view of a catena of decisions of the apex court, and therefore long pendency is to be spurned and a direction be issued to the trial judge to try and dispose of the said case at the earliest. First. Next paragraph. Notice to OPs. Go to the OPs. Notice to who are the OPs here? Yes,
Only
government.
My lords, since this is listed for removal of defects,
That's all right. I am overruling.
I don't have brief.
Now, since Madam has given up the prayer in respect of other cases, we can dispose of this. After all, these are all. Okay. Learned AGA Mr. Behura is requested to accept notice for OP numbers 1 and 2. 1 and 2. First off, do you want to say anything? Will direct them to try and dispose of the notice. Although he made some submission as to the maintainability of the writ petition, that may not factor more in a case where fundamental right is allegedly violated. First, be that as it may. Next paragraph. Justice of the case warrants that a direction be issued to the learned judge of the court below to try and dispose of the subject case within an outer limit of 9 months.
God bless.
9 months.
My lords, in fact,
Ordered accordingly and writ petition is disposed of. One. One sentence, just office objections are overruled.
Item 5.
Next, the registry to send a copy of this order to the learned judge of the court below by speed post immediately for information and needful action. Yes.
Item 5.
Yes. 5. 20-year matter. 24 years. Call out the name of the party and the advocate. We can't keep them pending like this.
Advocate Messrs. J.B. Sahu. Advocate Messrs. J.B. Sahu. Advocate Messrs. J.B. Sahu.
Right. In this 24-year-old matter, counsel for the petitioner is absent. So also recall out the name of petitioner.
Multicolor engineering.
Correct, that only.
Multicon engineering. Multicon engineering. Multicon engineering.
First, neither counsel nor the petitioner is present before the court. There is no response to the call out made by the made by the court officer on instruction of the court thrice. First up, in the above circumstances, this court presumes that the petitioner has lost interest in the matter and therefore interest in the prosecution of the matter, and therefore the case is dismissed for non-prosecution. First up, registry to send a copy of this order to both the petitioner and the OPs by speed post immediately. Next.
Item 6.
May pardon, my lord, I am on BC, my lord. The appeal for the same. My lord, the present petitioner challenged the order of the collector where the allegations were considered regarding construction of building without by violation of the approved plan, my lord. The approved plan issued by the Raurkela Development Authority has not been considered, has not been implemented while constructing the building, my lord. The complaint were raised.
You take notice. Let us see. Issue emergent notice.
Notice 3, 4, 5. I will take notice.
Learned
3, 4, 5 notice
is requested to accept notice for 1 and 2. Emergent notice to the rest. Okay.
Item 7.
Yes. None appears. Call of provocation. Next.
Item 8.
Item 8, let's say my plea, lordship. Here, lordship, Annexure 1 series is a dependency including all documents that is still pending before the Commissioner Secretary. Case is dependency is that the petitioner has filed a dependency statement attaching all the RTA documents where the petitioner tried to maintain the grievance for the that.
What is that grievance?
That a certain school has been able to get granted aid suppressing material facts and by submitting some false documents which was not in consonance with the rules which are required to be availed granted aid. For that reason, RTA document sought for. After obtaining the RTA document, this petitioner filed a dependency before the authority to consider all these things for a cause inquiry.
Can you take fall on the representative? The short grievance of the petitioner is as to non-consideration of a series of representations which he has made to the authorities, alleging that the school in question has secured a grant in aid by suppression of certain facts and by fraudulent means. Also, learned counsel for the petitioner submits, and learned AGA of Mr. Behura on request appearing for the official OPs agrees that the representation, a call may be taken by the jurisdictional OPs on the subject representation within a reasonable time, after giving an opportunity of hearing to all the concerned. First off, this is fair. Next, in the above circumstances, petition is disposed of. Then granting a period of 8 weeks for compliance.
The opposite petitioner one may consider. Opposite petitioner one may consider. One.
Only one to
One.
Next,
Item 9.
since this order is made ex parte, the private respondent, comma, it is open to, what is that way, go to title? Private respondent. number
Three does.
Comma, it is open to him to seek recall of this order if grounds do exist. Therefore,
Right. Grateful.
registry to send a copy of this order to OP3 by speed post.
Grateful.
Next.
Item 9.
Every pardon, Your Lordship. Item number 5, Your Lordship. 2-year-old matter, Your Lordship. I am for the opposite party. I'm sorry I was late, Your Lordship. My name may be referred. For the opposite party.
Item number 5.
B. Panigrahi.
Yes. Sure.
Great one.
No. Yes.
Please, Your Lordship. The claim of the petitioner by the Annexure 4 has been rejected for counting of his ad hoc period of service for placement in lecturer and reader, Your Lordship. The similar matter.
Period to be counted. Ad hoc
Yes,
period
Your
to be
Lordship.
counted.
Your Lordship.
Any such ruling is there?
Yes, Your Lordship. But by the Annexure 5, I have enclosed the order by First Learned State Administrative Tribunal in similar issue.
Now that is rejected.
Yes, Your Lordship. By the Annexure 4.
We take notice. Yes. Go to title. Once I say title, immediately you should take me to the title.
I'm sorry, Your Lordship.
Our AG is requested to accept notice for OPs. Next.
Great.
Item 10.
My lord,
Yeah.
please, your lordship. This is a matter under RERA Act, my lord. May I pray the matter may, similar matters have been filed. It may come after vacation with WPC number
Learned AG, learned counsel for the petition.
30679.
WP number. So
Yes, sir, of 25, of 25.
Item 11.
Speak.
Say Hemant Chotra matter.
Subject to disposal of appeal.
Writ appeal that pending.
Then. Connected matter also same. No.
Item 12.
Item 12 is a petition filed by the petitioner in person, my lord. This is in respect of the amnesty scheme floated by the opposite party BDA for consideration of
Take notice. Yeah, AGA request. AGA request of notice for 1, emergent notice to 1 and 3.
yes, my lord.
1 and 3, emergent notice to 2.
3 my lord notice because BMC have their
Okay, what you-
own panel.
2 and 3 emergent. Okay. Next.
Item 13.
This is the second round litigation, my lord. My claim for RSP has been rejected under Annexure 8, my lord.
Rejected now.
Rejected, my lord.
Then we have to examine that. OP number. Issue. Notice. AGA accepts notice for OPs. Yes.
Item 14.
May I please, Lord?
Ah.
Lordship, this is the Hemant Chotra.
Farida.
Yes.
Yes.
And similar order has already been passed.
Identical. Yes, brother. Hemant Roy. Okay.
Item 15.
Oblige.
15 also same, my lord.
Same.
But no one is there for the
Correct.
external.
Yes.
Item 16.
May please.
In action on the part of the opposite party number 1, appeal against the order of OP number 2 is pending since May 2025. Till date, that has not been taken up. My grievance is before the
When
Shaman.
if you had filed the appeal?
I have filed since May 2025. That is Anacha 3.
May. Not even 7 months are over.
Yes, till date, that has not been taken up.
Not even once it is taken.
No.
Short prayer of the petitioner is as and personal. Notice to OPC is dispensed with. You are not a party, whether a state is a party? No.
No, my lord, this is Jagannath temple, they have their own name.
Therefore, notice to OPC is dispensed with because of innocuous nature of the prayer. First. Next paragraph. Learned counsel for the petitioner submits that is appeal number
3 of 2025.
3 of 2025 filed before the OP3.
OP number 1.
OP number 1 is remaining unconsidered, and therefore a direction be issued for consideration of the same at the earliest. First, it submits that right to speedy justice is being a facet of Article 21 of the Constitution of India, such a direction is the warrant. Having heard learned counsel for the petitioner and having perused the petition papers, this court is of the considered opinion that the petitioner's subject appeal ought to have been taken up at least once by this lapse of time. Personal. That having not happened, the case is made out for indulgence of this court for requesting OP number 1 to take up the appeal for consideration immediately. Personal. All contentions are kept open. Ordered accordingly, WP is disclosed. Yes.
Item 17.
May I please, Your Lordship? The grievance of the petition is very limited, my lord. My husband died on 3rd November 2024. After the death of my husband, I applied the legal aid certificate. My legal aid certificate is pending before the opposite party number 4, my lord.
Consider that application.
It was in fact not considered on the ground of that second wife consent.
You reject on that ground. How can you keep it pending?
Annex 7, my lord.
Short grievance of the petitioner is as to long pendency of his application, her application,
my lord,
for grant of legal heirship certificate. First one. Learned AGA Mr. Mohanty, on request accepting notice for the OP, very fairly submit that he would instruct OP number 4 to look into the grievance of the petitioner if reasonable time is granted and all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, 8 weeks. Next.
Item 18.
Lordship, it is a second round litigation whereby the petitioner's prayer for UGC scale of pay is rejected under Annexure 43.
What is wrong with that order?
It is the scale of pay has been rejected.
Correct.
On the ground that they are not entitled. And in a similar matters, notice is issued.
Notice is ordered already. Identical matter.
Identical matter.
Issue.
It is a fact.
Emergent notice. Mohanty, learned AGA requested to accept notice.
1 to 3.
3.
Others are independent.
Emergent notice to the rest. Yes.
Item 19.
Call along with the people. Yes, sir.
Similar method, that is
19 in respect of that guest teacher. It is the advertisement of 2023.
Similar methods.
Notice is ordered. Issue emergent notice. Call along with the people. See, AGA is requested to notice.
No.
Emergent notice to OP number 6. Call along with W. Yes.
Item 20.
The other matters are also set.
Yes.
Other matter.
Item,
Yeah.
item 20 minutes, I'm a work contractor minutes. I was given a work I completed the work way back in December 2023. It's a trauma care hospital between Cuttack and Balasore, my lords. So, my lords, they are not taking over my work. They are not paying my dues. My lords, may see Annexure 11.
If your representation is considered, it will do justice to you.
My lords, I have given multiple representations. Even the officer of the state.
Let them take the call on that.
My lords, just see that letter. My lords will understand what.
No, I agree with you.
Yes.
I agree with you, but I cannot take a decision because I am not the contractor. I am not the person who awarded the tender. They have to do that.
No, my lords, what is happening? Because the state
short the grievance of the petitioner is reflected in prayer 2, which reads as under. Next point. Learned counsel for the petitioner submits that despite giving multiple representations, the file has not moved and reasons are not known. Learned AGA, Mr. Lenka, on request appearing for the OPs, very fairly submits that he would instruct the jurisdictional OP to look into the grievance of the petitioner, as has been reflected in the subject representations within a reasonable time if all contentions are kept open. With this proposal,
Annexure 10.
counsel for the petitioner is agreeable.
No, 10. 11 is their letter, the opposite party's letter, admitting my claim.
In the both circumstances, representation dated 11/8/2025, Annex 10, to be considered within a period of 8 weeks. And the result of such consideration should be made known to the petitioner as well. First one, if delay is broken, the same shall be viewed very seriously in the next level of litigation. Okay.
Lords, may I just pray? This 8 weeks may be reduced. I mean, under tremendous financial pressures, that may be reduced. Much.
Item 21.
Yes.
Second round litigation. The opposite person number 1 rejected my prayer.
Yes, sir.
Contempt cases now. Officer. Just a minute, sir.
The opposite person number 1 rejected my prayer for regulation. Though I am,
how many years you have put in service?
I am continuing since 1/3/1989.
89?
Yes, ma'am. Annexure 16
emergent notice. AG is requested to accept from
3 and 4.
3 and 4.
Notice to 1 and 2.
Notice to 1 name.
A similar matter, item 64/65,
64, 65.
67, 68,
67, 68.
and 84.
84. The other private parties separately looking to and make it. Okay.
Item 22.
Matter relating to extinction of great faith covered by Saraswati Voice judgment. Yesterday, similar to yesterday's item 46.
Same order. Next.
Item 23.
Please, Lordship, this item is covered under your Lordship's judgment. State of Odisha versus Santanu Kumar Swang. The arrear salary cannot be barred to 3 years, applying Tasrif Singh judgment. This matter is a covered judgment of your Lordship in the state of Odisha versus Santanu Kumar Swang. The arrear salary, claim to the arrear salary cannot be restricted to 3 years.
He has not filed any representation. Let him file and he
No, reject it. Go to the prayer call. Order number 20 shall not be said to say. He has sought for quashing of that.
then notice.
Or we can do, we'll tell him to make a representation.
In the light,
Then in the light of that decision, the authority has to take action.
Annexure 9.
Then no enforcement of the impugned order. All right.
Annexure 9.
Lordship may direct that in the order direction for the consideration of the representation.
That's all. That where is our order?
Annexure 9.
Annexure 9. Petition prayer reads as that. Counsel for the petitioner submits that the impugned order is unsustainable in view of a coordinate bench decision in writ appeal number 3225 of 2003 between State of Odisha and another versus Shantanu Kumar Swain and others disposed of on 17/7/2024. First note. Learned AGA Mr. Yadranka request starting notice for the vote is very fairly submits that. If notice for OP numbers 1 and 2 very fairly submits that. If a representation is given in the light of the division bench decision, comma, a fresh decision would be taken by OP number 2. 2 or 1, who should take the decision?
OP number, director.
Impugn order is by whom? Director. OP number 2. OP number 2. First off. He also assures that.
OP3, man. Director is OP3.
OP3.
Right. Sorry.
No. Governing body. Director is OP number 2.
2. Sure.
He also assures that till consideration of the such representation, if one is made, comma, no coercive action will be taken against the petitioner pursuant to impugned order. First, with this proposal, counsel for the petitioner is agreed. Next point, in the above circumstances, petition is disposed of, giving a period of 4 weeks for a petitioner to file appropriate representation. And if one is filed accordingly, comma, the same shall be considered and disposed of within 8 weeks next following. First, in that connection, all contentions of the parties are kept open. First, that the impugned order shall not be given effect to till disposal of the representation happens. Item 24. Yes.
Myself, Advocate Sandharani Khan.
What by Saraswati Bhoi matter? Saraswati Bhoi, the application of.
Yes, the same 22. 24. No, we have disposed of that matter. No,
representation has not
the same order.
Representation has not been made.
No representation made. You have to make the representation.
Can you give the petition?
Petition prayer reads as that. Counsel for the petitioner submits that his case is covered by the claim of the petitioner. Claim is covered by the decision of
Saraswati. Your Lordship decision.
The coordinate bench decision of the decision of this court in WPC. Coordinate bench it is. Division bench decision. Counsel for the petitioner submits that if permission is granted, liberty is reserved, is going to make a representation, and accordingly a direction be issued for consideration of the subject representation in the light of the division bench. First, this is very next. In the above circumstances, petition is disposed of. Petitioner to make representation within 3 weeks, and if one is made, OP number, we should consider the jurisdictional OP shall take a decision thereon within 8 weeks next following. First, all conditions are kept open.
My Lord, since I can't permission, there are 7 other matters similarly situated spread over the list. I have made a list of it.
Which one?
Similarly situated matter spread over the list. Item number 29. I have made a list.
You have made the list of them. Same.
Just tell me.
Just share a copy of the list with him also. Get a xerox of that.
I've given.
Get a xerox of that and give it. Yes.
Item 25.
My Lord, Advocate Sandharani Pani from BC Barampur, my Lord, and challenging the wrong calculation of UGC scale of pay, my Lord, of her late husband, and challenging NSA 3, the letter issued by the OP, my Lord.
Issue emergent notice. AG is requested to accept notice for OP numbers 1 and 2.
OP number 1, my Lord.
OP 2 also. Principal Secretary.
Secretary, yes, my Lord.
OP number 1. First, emergent notice to the other OPs.
My Lord, item number 60 also similar matter, my Lord.
60.
60.
60, but look into this first item and then do that. Yes.
Item 26.
7/10/2023, the petitioner has applied for a license for MMDR. That is Mohammedan marriage and Mohammedan Marriage and Divorce Register for Bhadrak Rural Town PS. And in the meantime, inquiry report, everything was submitted before the government. That is inquiry report annexure 3 series.
To function as a registrar of marriage. What is your client?
My client is unemployed?
No, unemployed.
Unemployed.
If he is employed, then he cannot be. Let's see judgment.
Another, and that is another case. So, it's going to.
Yes, brother, take decision, only taking a decision.
This is correction. The register of Mohammedan marriages and divorce, MMDR.
Correct.
Specifically marriages. This is the corrected.
You have corrected it now.
Is this?
Thank you. Give it back. Yes. Call contempt center.
Yes, sir, notice item 1.
Officers are waiting, na? Yes. Where is compliance report? I have filed that.
Time to give me a copy. Sure. Why not? Your copy is here.
Yeah.
Have you filed it, my lord?
You have filed it here?
Yes. He filing. It's a hard copy.
They have complied with.
I believe, let's try to believe. I do believe them.
Background.
This complaint alleges, this case alleges, this complaint alleges violation of order dated
22/8/2025,
rendered by this court in WP number
14083 of 2025,
wherein the operative portion reads as under. Next paragraph. The OPs having not complied with the order within the period prescribed by the said order, comma. The notice was ordered to the OPs and they are personally present before the court this day. First off, they are represented by learned AGA, Mr. G, who submits that he who has filed the compliance affidavit sold to by OP number 1, the collector of Balasore district. First off. Along with the affidavit, office order number 4464, dated 16/12/2025, has also been filed to vouch that there is compliance. First off. Next paragraph. In the above circumstances, the proceedings are dropped, reserving liberty to the complainant to take up appropriate proceedings if there is any grievance left out. First off, in that connection, all contentions are kept open. First off, the swift action taken by OP numbers 1 and 2 who are present before the court is appreciated.
Personal appearances dispatch.
Yes, personally present we have said. Yes, madam. Next.
Item 27.
My lord, this is a matter regarding to grant of differential salary under UGC scale of pay, which is covered by a decision of this Honorable Court under Annex 10, Your Lordship. And thereafter has been confirmed by the Honorable Supreme Court, Your Lordship, as the SLP has been dismissed as well as review has been dismissed.
Review also is dismissed. Yes, that filed the review.
You have filed a representation,
Your Lordship.
That is a representation in the light of this.
Yes,
yes. Petitioner had given a representation dated 35/2025. Correct?
Yes, Your Lordship. 35/2025.
At Annexure 11, requesting the Commissioner cum Secretary Higher Education Department for payment of UGC scale of pay arrears that have accrued, allegedly accrued due during the period between 1/1/1986 and 31/12/1995. First, counsel for the petitioner submits that the said representation needs to be considered in the light of the decision of this court which has been affirmed by the apex court as well, comma, review petition against the same having been rejected.
Yes.
First, the details of these are mentioned in the, whether you are mentioned in the representation.
Lordship,
Yes, the details of the same are mentioned in the representation also. First one. Learned AGA Mr. Lenka on request accepting notice for the OPs 1, 2, and 3.
Yes.
Comma, notice to 4 having been dispensed with. Very fairly submits that he would instruct his clients to look into the grievance of the petitioner in the representation in accordance with law if all contentions are kept open and a reasonable period is prescribed. First one. This is fair enough. Next paragraph. 8 weeks.
Your Lordship, that representation is dated 2/6/2025.
Correct. 2/6/2025.
Because inadvertently it has been mentioned 35/2025.
But you have mentioned the 35.
Yes, that wrongly, Your Lordship, because the postal receipt shows 2/6/2025.
That's 2/5/2025.
2/6/2025. Grateful, Your Lordship.
Item 28.
This is the matter relating to transfer of assistant teacher and appeal is being referred under Annex 4 before OP number 2, my lord. My lord, referring to the judgment, pass the similar order in identical matter.
Para 4.7.
My lord.
4.7.
On Monday, you lost the pass to the similar matter.
Yes.
Item 29 has been disposed of. Item 30.
Wrong fixation from RSC. Similar matter already is notified.
Notice is ordered. Issue emergent notice. The DG is requested to accept notice for OPs.
Item 63 also same.
62 also same.
63.
Issue notice. The DG is requested to accept notice for the OPs. Call along with WP numbers. Same order in 63 also. Yes.
Item 31.
On the basis of recommendation of my lord of the MLA, I have been transferred to some other place. And in 28, item 28, your lordship is similar matter. In that case, he has filed the appeal, but I have not preferred appeal.
You preferred appeal in the midst of that decision?
Yes, ma'am.
When the order was made?
Order was on 10/7/2025.
Now, have you joined already?
My lord?
You have joined in the
yes, yes, ma'am. 4.7, your lordship is in that.
The of the petitioner is against transfer order dated 10/7/2025. First, counsel for the petitioner submits that this transfer could not have been made at the instance of the local MLA.
Yes, ma'am,
local MLA. In the light of decision of this court in which is that
there is Ranjan Kumar Tripathi.
Ranjan Kumar Tripathi versus Swayam to that.
In WPC number 20,875
of 2025. Disposed upon?
Disposed upon that is 27/11/2020.
27/11/2020. First, when asked, comma, let a counsel for the petitioner submits that he is going to prefer an appeal available at the departmental level, at the department, and in that connection, liberty be reserved. First off, with this proposition, counsel for learned AG appearing for the OPC is agreeable. First off, next one, in the above circumstances, petition is disposed of, giving liberty to the petitioner to file the departmental appeal within 2 weeks, and if the same is filed accordingly, it shall be decided on merits in the light of observations made by this court in Tripathi case. So far.
The order dated 10/7/2025 is confined to only petition number 3, serial number 3.
That's what.
Yes, ma'am.
No issue.
Item 32.
Number 32. Yeah.
Lordship, I'm hereunder challenging the Annexure 4, wherein the petitioner was suspended from her post at page number 16, Lordship.
Then what happened?
Lordship, the problem here is that the suspension order.
The 1/11/2025. The 6 month period is available, na? Ajay Singh, which is that?
90 days, Lordship.
90 days?
90 days, Lordship. No. Provide charge sheet, Lordship. Provide charge sheet. But here in this case, Lordship, nothing has been mentioned as to if the departmental proceeding is contemplated or it is pending or any criminal charge is pending against the present petitioner, Lordship. Lordship, under Rule 12 of the CCCS rules, Lordship, suspension is provided.
Inquiry.
Pending
or pending disposal of the criminal case.
Lordship. Or contemplated.
Where it is not stated,
Lordship.
It should be presumed in the decision of apex court. Nobody will suspend you for some festivities.
No, Lordship.
There will be something with some misconduct. Maybe your client has not told you.
Lordship, that is there. That is there, Lordship. Previously, the BEO has issued a show cause notice to us that we had given our reply. Then, Lordship, that reply was not accepted. Then after that, we given our apology letter. After that, we were suspended, Lordship. Show cause is there. Yeah. But, Lordship, it must be written. That order is cryptic, Lordship. Lordship. Lordship, I'm
direct them to hold inquiry and dispose of the inquiry within reasonable.
So I'm relying on one judgment, Lordship, of the Allahabad High Court.
Sure. Allahabad High Court.
Lordship.
Of which year?
Lordship, 2001, Lordship.
2001. Law has marched like anything.
But this same issue is involved. That is why I relied on that, Lordship.
No, that's all right. But now apex court said, where suspension order in so many words does not mention about pendency of the disciplinary proceedings or a criminal case, it should be presumed. There is such a decision. Therefore, what I suggest is, let them, if they want to hold any disciplinary proceedings, they want to hold because they have rejected your representation.
Not true.
Natural. But they should, you should complete it within 3 months. Yes. All right. But petitioner is knocking at the doors of the court for the quashment of suspension order dated 1/11/2025. A copy whereof avails at Annexure 4. First, Learned counsel for the petitioner submit that the suspension order is not speaking order. It does, semicolon. It does not mention as to why the petitioner has been suspended. Semicolon. Under the extant disciplinary rules, suspension can be ordered only during the pendency or in contemplation of a case. And therefore, the impugned order is liable to be struck down. It's first one. Next paragraph. Learned DGA appearing for the OPs with Lenka opposes the petition, contending that the suspension is dated 1/11/2025 and that the case papers make it very clear that it is for a particular misconduct, semicolon. It draws attention of the court to the show cause notice issued by the authorities and the petitioner's reply to the same, which has been rejected as well. First one. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the submission of learned DGA as above. First, ordinarily, the suspension order should specify as to why suspension is being made and whether any disciplinary proceeding is contemplated or criminal case is pending. First, that would be an ideal situation. First, but the law operates with the reality of life. First, there is abundant material on a record which shows that petitioner has allegedly committed some misconduct, semicolon. A show cause notice was issued to him and he has replied to the same.
But to her.
Huh?
Show cause notice issued to her.
To her instead of me. And the reply has been rejected as well. Wide office order dated
1/11/2000.
No. Rejection of your
Annexure 3, order dated
29/10/2025 at Annexure 3C. First, next one. In the above circumstances, petition is liable to be petition is disposed of. Directing OP number, it should hold the inquiry. OP number 4 to hold and accomplish the inquiry within an outer limit of 3 months.
But from the date of this issuance of the Annexure 4?
No.
From today?
Reckon from this day.
And petitioner,
excluding the period of adjournments that the petitioner would seek.
And petitioner to cooperate.
First, petitioner shall cooperate in the subject proceedings. First comes. Delay shall be viewed seriously. Next.
Item 33.
May I please your lordship, the petitioner before your lordship challenged the order of dismissal, your lordship. On the ground of submission of a fake certificate from Utkal University, that is B.Ed, the petitioner has been dismissed from the service, your lordship.
Provision is there.
Appeal provision is there. Under which section? No, against dismissal there is an appeal.
Dismissal?
No, against dismissal there is no.
Against dismissal, no.
Take notice.
Lordship.
No, you would like to accept notice.
Obliged.
For OP numbers 1, 2, 3. First emergent notice to 4 and 5.
Obliged.
Item 34.
Yes.
Here, my lord, the petitioner is now presently working as an assistant professor. He wants the benefit of the career advancement scheme. This is a financial cooperation in terms of the government resolutions under Annexure 6. And
your representation is not
yet been attended to.
Petitioner's prayer reads as under. Next one. Counsel for the petitioner draws attention of the court to the representation of his client made on 19/8/2025, a copy whereof awails at Annexure 10, wherein he has made request for promotion under career advancement scheme, taking into account the previous service. Keeping in view the decision of this court in writ appeal number 675 of 2024, disposed of on 23/7/2025. First, learned counsel for the petitioner submits if a direction is issued for consideration of the subject representation. We should consider
the OP number 2, man.
OP number 2, comma, justice will be meted out. First. Next paragraph. Notice to OP numbers 2, 3, 4 is dispensed with since a petitioner is seeking an order to pass an order on his representations, keeping open all contentions of the party. First, next paragraph. 8 weeks.
My lord, all learned appear for the university. If his presence will be noted, it will take MK Khutia. Senior.
You want to,
name will be reflected, I will be benefited.
That instead of that notice dispensed to learned counsel Sri so and so
MK Khutia.
OP numbers 2, 3, 4. First stop. Okay, fine. Then according to that.
Item 35.
OP number 4, the present OP number 4 has made a 5-storied.
Yes.
The OP number 4 has made a 5-storied building without applying the statutory requirement, that is the permission under section. My lords, I am the neighbor, adjacent plot owner, and encroaching upon my land, he has erected a building without any building plan. That is envisaged under section 50.
No, if you want the encroachment to be removed, then it is suit.
No, it is prescribed under section 91 of the OD Act. I filed a complaint. Complaint was dropped that civil suit is pending. Civil suit I have filed only for that enclosed portion, but the entire building has been erected without any building plan. I have filed the documents that he has not applied for any permission, and no permission has been granted for erection of the building, which is a mandatory requirement.
Take notice.
Manners.
He requested to accept notice for 1 emergent notice should be rest. Next.
Item 36.
Remember the TDC of my lord's order is there.
Issue emergent notice. JSC, AGA, requested to accept notice for OP numbers 1, 2, 3, 4, 5, 6. All OPs.
Yes, sir.
No. Commissioner Bhubaneswar Municipal Corporation, you don't appear for that.
No.
OP numbers.
Accidents are for
1, 2, 3,
1, 2,
5, 6, 7.
5, 6, 7. Emergent notice to form.
All along.
Number.
I will serve extra copies to the council.
No, you have to send the notice to OP number 4. Yeah.
Item 37.
Yeah.
Even the second round of litigation, now the claim of the petitioner for to get the revised clause rejected, similar matter is also already issued.
The DG requested lots of notice for the OPs, all along with WP number slides.
Item 38.
The petitioner challenges the order of rejection by OP number 4 under Annex 11 of the application for voluntary retirement of the late husband of the petitioner. Earlier, the late husband of the petitioner filed an OA before the State Administrative Tribunal. After his voluntary retirement application, no action was taken, and he filed the OA, which was transferred to the Hon'Ble Court, and this was disposed of by the order under Annex 8. You will also kindly see page 30. Here a direction was given to OP number 4.
For?
You will also kindly come to page 32, paragraph 6. Having had learned counsel for the parties and taking into account the fact that application for voluntary...
To take decision on Annexure 1.
Yes. Annexure 1 is the application for voluntary retirement filed by the late husband of the petitioner.
Now it has been rejected by...
Rejected totally reasons which are not legally acceptable.
I'll take notice.
Okay. Like I requested to sub notice for. Okay.
Item 39. Basing under Annex 11 passed by this Honorable Court order, I have made representation before the OP number 2 and 3. That has not been consideration received.
For regulation of service?
Minor. The reason and further preferred financial benefit lesson.
The petitioner, by his representation dated 3/12/2024, had requested the principal come secretary, Salipur Autonomous College. Autonomous College?
My lord.
Is it government college?
My lord. And later on taken over and government college. Principal Salipur.
Stop. In the said representation, he has requested for permission to rejoin as lecturer in the Department of Chemistry. And for also regularization of his service along with all benefits. First one. The net counsel for the petitioner submits that representation of the kind cannot be kept in limbo indefinitely. First, learned AG appearing for the OPs.
Annexure 6, it shows that a departmental proceeding is pending.
Correct, but you take a decision on that.
Yes.
AG appearing for the OPs opposes the petition, contending that some departmental proceeding is pending against the petitioner and therefore no relief can be granted to him. First off, having so contended, now he agrees to instruct the OP number
2 and 3.
2 and 3. Who will take the decision?
As per the
jurisdictional OPs to take a decision on the subject representation if all contentions are kept open and if reasonable time is prescribed. First off, in the above circumstances, this court of 8 weeks.
Item 40.
Yes.
Lord, here the petition is working as a lecturer in a block grant prayer, but your lordship have a glance. The recommendation is at page 20.
It is recommended also.
Also recommended.
Who recommended?
The director has recommended to the government.
Government has to take a call on that recommendation.
Yes.
That is the...
And the representation way back, yes, filed in 17 and the two.
No, that is already recommended.
Yes.
On the basis of representation, the jurisdictional authority has recommended his case. But government has to take the decision.
Yes.
Learned counsel for the petitioner submits that the claim of the petitioner for granting block grant for block grant is recommended by OP number 2. Why the order dated? Why the letter dated?
Annexure 5.
Letter dated
16/1/2013.
16/1/2013 at Annexure 5.
Left side top.
And despite that, no decision is being taken on the claim of the petition. First. Therefore, he requests interference of this court. Next one. Learned AGA, Mr. Lenkar, on accepting notice for the OPs very fairly submits that if reasonable time is granted, there would be no difficulty for considering claim of the petitioner in accordance with law, keeping in view the recommendation. Recommendation is dated what? Is it
That is
correct?
dated 25th of May 2013. 25.
Correct date.
2013.
Annexure 5.
Annexure 6.
Annexure 6.
Page 21.
What you have written now?
Annexure 5 document के ऊपर लगे recommended claimants for block grant under GIC. Annexure 5 है. Top. ठीक है. Sheetal date होगी 16/1/2013.
That basing on
2013 it is.
That is, here it is recommended claimants for block grant under GIC. That is the recommendation. Annexure 6.
The Annexure 6
the release of block grant.
Annexure 6 is the recommendation of the director to the government.
No,
That
5
is-
is the recommendation.
Yes, you
5 is the recommendation.
in the bottom, it is written director higher education and will
Which that there's no difficulty for going person. This is fair enough. Next paragraph. In the above circumstances, petition is put up 8 weeks. Who should take? Number one. Copy number one.
Copy number one. Secretary.
All good. Next.
Item 41.
Limited grievance in that the present petition of the secretary of the masjid has made a
Make use of the mic.
present petition of the secretary of the masjid has passed a resolution with regard to approval of the committee on management, which is pending before the opposition party number 2, my under annexure 1, my
Approval of management.
committee of management, masjid committee of
Masjid committee.
yes, ma'am.
Approval is required under which section?
36, ma'am.
Read section 30.
That is the registration.
What act it is? Wakaf Act.
Okay. Every
Petition prayer reads as under.
whether
Counsel for the petitioner submits that the Wakaf Act requires approval at the hands of government. Wakaf board. Wakaf board. For the formation of the management of the masjid committee. First, he submits that all papers have been already filed with the Wakaf board and no decision is taken in that regard. First, therefore, he requests interference of this court. Next one, notice to AG, Mr. AG is not there.
Not there.
Notice to OP is dispensed with since prayer of the petitioner is innocuous. First of all, he seeks a direction to the OPs for consideration of the claim for approval of the management committee.
OP number 2, ma'am.
OP at the hands of OP number 2. First, in the above circumstances, petition is disposed of, directing OP number 2 to take the decision on the claim for approval of the management committee within an outer limit of 8 weeks. All contentions are kept over. Registry to send a copy of this order to OP numbers 190 by speed post immediately. Next.
Item 42.
May I please put? Well, here my limited grievance is the petitioner appointment, the petitioner my lord, applied for appointment under the rehabilitation assistance scheme. My lord, in his application, he has stated that he applied for junior librarian.
Instead of junior
librarian. Your lordship may kindly turn to annexure 2 at page 13, his application.
Now, then what happened?
My lord, thereafter, my lord, after processing the application, now he has been given appointment as a junior clerk. That is under annexure 4.
With that cadre.
My lord, junior clerk, your lordship may kindly come to page 25, serial number 9.
No, I'm asking a question to you.
Yes.
What is that cadre?
My lord, so far as junior librarian is concerned, my lord,
my qualification is befitting for the post of junior librarian. And accordingly, I have applied for the post of junior librarian while submitting the application under the rehabilitation assistance scheme. But I am conscious of my limitation that so far as rehabilitation assistance appointment is concerned.
For holding body and soul together.
Yes, yes. My lord, I am conscious of that. So therefore, my lord, I have made a representation to the director. Higher education I have not yet joined. That let the director consider my case for the post of junior librarian. Because the post of junior librarian is lying vacant in the same college.
Vacant.
Lying in the same college.
You are right. Your right is to hold your body and soul together.
My lord, I am conscious. My lord, I completely. My lord, may I suggest one thing? My lord, since I have made a representation to the director.
Make a representation, and if I direct them to consider, they will say because of the High Court order, we have given the post to you. That cannot be.
Then I will be permitted to withdraw.
Petitioner, having argued the matter for some time, vociferous, now seeks leave of the court to withdraw the petition, knowing the mind of the court. First,
with a liberty to approach.
This court of as having been withdrawn.
With a liberty to approach.
With no liberty. First, registry to send a copy of this order to all the OPs by speed post for their file.
Item 43.
The land of the petitioner was brought under the town planning scheme, and town planning plot number was assigned to the petitioner. In the meantime, 7 years has been passed, but they are not developing the land, nor refunding the 40% of the land deducted from the land of the petitioner for development purpose.
What's the Supreme Court has said?
Either they have to hand over the development.
Suppose if they do not do, what is your right to get back the land?
They have to, because whether they will develop the land or to refund, they have not intimated me.
Or to return the land?
Either way. Either to develop the land.
Where is that?
I have made in page 7 of the.
No, what is the law on the point?
Law of the point that they have to develop the land. For that purpose, they have taken the land in the year.
They do not develop.
So the 40% of the land they have deducted from my purchased land, they have to refund the sum.
Take notice. But Supreme Court said something else. Supreme Court did not agree with this proposition. Anyway, the ASC is requested to accept notice for 1, emergent notice to 2. Next.
Item 44.
Offered by your lordship's order, my lord, with regard to the RACP.
Same prayer you made it?
Yes, ma'am. Same.
Item 45.
My pleasure, let's. Prayer, my lords. The petitioner was initially appointed as a PT in a non-recognized school, my lord. And later on, he has not been allowed to attend the, sign the attendance register. In fact, my lord, appeal lies before the director.
24B.
24 is the tribunal, my lord. The director, this is non-recognized school only. It has to director. But some delay is there, my lord. That will be continued. I wanted to make an application for the director.
How much delay?
Well, it is around 8 years.
No.
But still, my lord, my humble submission is, my lord, they're allowing me to function in the school. I have annexed the documents till 2023.
When the order was made?
My lord, terminating me. No order is passed. Simply, they are not allowing me, not recommending my name to the board authority for recognition, renewal recognition. But they are allowing me to work in the school. I have annexed the documents, my lord.
Have you drawn the salary?
No, my lord. From the management, I got some price, my lord. Since 2024, I have been allowed to work in the school also, my lord.
Where is your salary?
My lord, in original school, salary is not been given, my lord. Known to everybody of my school.
I am not from your state. I do not. If you had signed, could you keep quiet for all these years? That I have been signing, I have been working, and you have not given the salary to me. This is wrong. You would have filed at least half a dozen writ petitions before this court.
But my lord, let's see the annex, my lord,
You, instead of me dismissing this, you withdraw with liberty to file the appeal. I will not control with this. Petitioner, having argued the matter for some time, now seeks leave of the court to withdraw the petition with liberty to approach the appellate authority in accordance with law. In the above circumstances, petition is accordingly disposed of. Next.
Item 46.
My lordship. Petitioner applied for MBD course, MBD Master in Education course. In entrance exam, he has secured 57.75 mark.
Yes.
In regular stage, he is not eligible for admission. In spot admission stage, he applied again. In spot admission, first phase for spot admission, he was selected. He was appeared Dibakar Patnaik Institute of Advanced Study and Education in Barampur. As per the rule, in spot admission, candidate should apply and physical present there in the date of spot admission. Well, on that day, he present there, and there are 19 seats vacant. So, yes, first page spot admission, my lord. Page number turn to page number 28. 16 candidates have been selected, and 3 seat kept vacant. It is arbitrary action by the college because citing that 3 seat is reserved for PWD category. But guidelines say in spot admission stage there will be no reservation category.
No. Apex court say
yes.
Even when the notification does not specify 3% reservation for PWD is a must.
Yes, but in regular stage, my lord.
No, everywhere. Otherwise, wherever you are filling.
No, my lord, it is specifically stated in spot selection there will be no reservation. My lord, see Annexure 4. Annexure 4. Page number 32. 32. Running page 32.8. Paragraph 8 or 0.8. Can I read, madam?
Fourth round waiting list, spot admission, the selection of the selection purely on the merit basis.
Yes.
There will be no rejection for this waiting list admission process.
Well, again, page 36.5. The same page 36.
The order appears to be wrong.
Page 36, page number 5. Because spot selection is the remaining seat which is vacant in the institute. Only after regular selection. In regular selection stage, all the reservation category can apply. But in spot selection, no reservation is required.
That would defeat the very purpose of the act.
No, my lord, because there are SC category, all other reservation category. Why only PWD category? That is the main point, my lord. Page number 36.
Take notice, let us see.
My lord, it is already class have been started. So,
when it happened?
Only spot selection means the last stage of admission.
When it happened?
1/11/2020.
But now you are just you have filed the petition when?
12/12/2025, because I have to collect all the document through RTI, or otherwise I cannot appreciate the court.
The DG has requested to sub notice for OP 1, 2, 3. Emergent notice to 4 and 5.
1, 2, 3, 4, my lord.
1, 2, 3, 4.
Yes.
Emergent notice to 5. Who is 5?
5 is the minorship, that student.
Another student.
Another student, which has less mark
than you.
Me, but
he is 57.75.
He belongs to PW. That is the point. My point is.
You mean to say he should not have been appointed, he should not have been given the seat at all?
If this reservation category is not applied, then he will not get a seat, my lord. But Annexure 1, it is also written there, the merit list for final spot selected on waitlist candidate admission has been prepared on the basis of candidate immediate entrance mark. In Annexure 1, my lord, which is impugned notice.
You take emergent notice.
Yes.
Piece of notice postponed. We cannot do anything now.
One
be losing classes, what to do? It happens because more than 1 month you took for collecting the documents.
Yes, because through RTI, my lord, otherwise I cannot appreciate this code.
But what entry order can be granted?
Yes, sir, subject to outcome of the writ petition.
What will be subject?
My admission. Otherwise, it will.
No. By entry order, we cannot do that way. If vacation sitting is there, I will permit you to move the vacation code if service takes place. Service has to happen on OP number 5.
Yes. My lord, I can submit that OP number 5 is the student of that college. Through college, it may be solved. Otherwise, I have no address. I have
to taking usual steps.
Yes.
In respect of OP number 5, petitioner is permitted to serve, hand summons to be served on the said OP number 5 through the college in question.
Yes.
Another thing immediately after service.
Yes, another thing, my lordship. There is one vacant seat till now, which is in annexure.
Any vacancy is filled up during the pendency of the petition. The same shall be subject to outcome of the petition.
Yes, another, my lordship, opposite party number 2 may be state may be instructed to get instruction whether that this student can be accommodated with that seat.
No, let us see. We do not
because only
we cannot now do that. Wait, what the objection they will file, we do not know. No,
take instruction about vacant seat only. Otherwise,
Item 47.
Oblige, my lords.
The second application, my lord. In this case, I have challenged the order of disengagement against that petitioner preferred appeal. Appeal also rejected.
Issue emergent notice. PG is requested to observe notice for. But for take all. Next. One minute. Just take one more pattern.
Item 48.
48, my lord, similar matter notice is done. Here, my lord, the rejection of the implementation with regard to my arrear salary only on the claim of Tarsem Singh, the judgment of the Honorable Supreme Court. But this Honorable Court has, in a writ appeal, that also I have relied upon, that in Haraprasad Rai's case, wherein my lord have passed the order, that has no application by relying on other judgment. But now they are saying, we are proposing to go to the Honorable Supreme Court that I might have burned. That is why it has been rejected. On a similar matter, my lord have issued notice.
Issue emergent notice. Issue emergent notice. Learned AG requested to accept notice for 192. Emergent notice to 3. Yes.
Both the matters identical.
Yes.
Item 49.
Next meeting.
Yes, I am working as speaker since 1990, and the authority council has allowed me to take the block grant as per the granting date order 2009. So I am eligible to get the granting date since 1996.
1695.
And so for the other similarly situated person is concerned, they have been granted the benefit. My prayer is that, that is under Annexure 3 and Annexure 5, in respect of the other institutions, So my prayer would be, my lords, the lordship may direct the competent authority to take a decision in view of the Annexure 3 and Annexure 5 of the petition. Lordship may kindly see Annexure 3 at page, my lord, 13, and my lord's Annexure 5 at page 19, my lord.
You take notice. Take notice. Show emergent notice. AAC is requested to accept notice for 1 through 3. Emergent notice to 4. Similar. Yes.
Item 50 has been disposed of. Item 51.
Come back. This was, this folder, 45. Okay, same matters. Okay.
Item 52.
52, my lord. Identical matter, lordship, kindly. Petitioner that gave us 2003. Now
22 years.
Yeah, 22 years, all of them sort of disengaged. Out of
it is not
out
all.
of 3 persons disengaged.
It is not all on a sudden. They were continuing pursuant to an interim order passed by this Hon'Ble Court. So after vacation of that interim order, they may have faced.
In respect of 4 out of 3, your lordship passed an order of this. And it's a 3 page.
You take notice.
My lord.
Yes. Let him take notice.
Similar order.
Let us issue emergent notice. Mr. G, learned AG requested to accept notice for OPs. Yes.
The same order, your lordship. Your lordship, and it's a page, your lordship, and it's a 3 descending order, and it's a 3. And it's a 3 descending order. Total 4 candidates. Out of 3, your lordship has passed this order.
52.
Item, page 15, 52. Page 15, descending order, descending order.
Item number which?
52.
52. We have directed notice in that matter, no?
Directed your lordship in this case, interim direction, your lordship directed to continue the petitioner in service till next date of hearing. Total 4 candidates, your lordship passes in respect of 3 candidates. Total 4 candidates disengaged in 1 order. Your lordship has passed in respect of 3 candidates.
This interim order. Issue emergent notice. G requested to accept notice for OPs. Counsel for the petitioner submit that in identical cases, that is WPC number 35117 of 2025. Interim order has been granted by this court on 9/12/2025, and therefore similar protection should be granted. Similar interim protection should be granted to the client. First, he has also placed a copy of that order at hand. At the hands of the court. First one, there is force in this submission. Next one, in the above circumstances, OP number 3 is directed to continue petitioner in service till next date of hearing. IIT school. Call along which I have the number. Sorry, I did not apologize. Yes.
Item 53, 54 have been disposed of. Item 55.
Yes.
Lordships, opposite party number 7 is the Sarpanch of the Lordships has misappropriated the government fund by raising the false and fabricated bills, your Lordships. Therefore, my representation is pending before the OP number 3, your Lordships.
Who are you?
I am the ex-ward member of the...
Ex-ward member.
Yes, your Lordships.
Has presented this petition with the following prayer. First, counsel for the petitioner submits that petitioner has sent a representation dated 21/11/2025, alleging a misappropriation of funds during the COVID-19 period, and that no decision has been taken on the subject representation. First, therefore, he submits, he seeks intervention of the court. Learned AGA Mr. G appearing for, on request appearing for OP numbers 1, 2, 3, 4, 5. 6 also.
My lord.
Public information officer.
Yes.
6. Very fairly submits that you would instruct who should look into.
OP3, your lordship.
OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, if all contentions are kept open and a reasonable period is accorded. First off, with this proposal, counsel for the petitioner is agreed. Next, in the above circumstances, petition is disposed of 8 weeks period. First, decision to be taken within a period of 8 weeks after giving opportunity of hearing to all the stakeholders, including OP number 7. Yes.
Item 56.
For RSV benefit, it's a similar order. I have corrected.
You have corrected it.
One copy to
That's AG also, na? There is no such culture in your file.
Yes.
This code of.
Item 57.
It was disposed of, my lord.
Yeah.
Notice was issued.
No, it's the disport of it, na? Notice is issued. No, disport of.
Similar matter, all similar matters.
Yeah, similar matters in the light of that Ashok Kumar Mohapatra.
Yes, yes, my lord. So the drafting alaga achi tha.
You should watch it in this. Yes.
Item 57.
Item 57, this is covered by Saraswati Bhoi. Item 57 and 96.
57 and 96.
I have given the corrected copy, but in the last, but one paragraph.
In the light of.
Yes, your lordship indicated.
Have you corrected that? You
No,
that
I have not corrected.
Yes, you had that sentence.
Yes.
And you had that sentence.
Yes.
This program.
I was 97.
96.
96.
96.
96 is also seen.
Item 58.
Your lordship, this is covered by Saraswati Bhoi case, your lordship.
Representation.
Yes, your lordship, under Annexure 5. And your lordship kindly observe that page number annex, your lordship, Annexure 4 series, order of the Honorable Apex Court, your lordship. Operative portion, page number 60. Page number 60. Order of the Honorable Apex Court in this Saraswati Bhoi.
Similar order.
That similar order, Mr. Francis.
Yes, similar order, but your lordship may observe that civil appeal number.
Similar order, my lord. Lordship.
Similar order. 68, same order. Great. Yeah.
Item 59 has been disposed of. Item 60.
70. 69.
59.
59.
59 disposed of. 60. Item 60.
Yes.
Item 60.
None appears for petitioner. Call of vacation.
Item 60 was, notice was issued. She was mentioning on VC.
That you have not, yeah, that lady from Balangir.
Baram.
Yes. Notice. Yes.
Item 61 has been disposed of.
1 and 2. G. Emergent notice 2, 3.
Item 62. Item 62.
The order of the tribunal.
My lord.
Only dispose of GIA case number 438 of 2025.
25.
But I will give it some time, more time. Short grievance of the petitioner is as to the pendency of GIA case number 430 of 2025 on the file of the State Educational Tribunal. Counsel for the petitioner submits that right to speedy justice is the set of Article 22. Next paragraph. Learned Behura on request appearing for the OP numbers 1, 2, and 4 opposes the petition contending that it is of the year 2025 and therefore the question of speedy justice, right to speedy justice would not arise. First, having so contended, now we agree to instruct OP number 4 to look into the grievance of the petitioner if he makes an application for early hearing, keeping in view other pendency. Okay, this is fair. Ordered accordingly and it puts in his disposal now. Yes, let him file early hearing application.
Item 64. The notice has been issued. Item 64.
Take notice.
My lords, this is
University. Emergency. Your fourth is yourself. OP4. Behura appears for OP4. 1, 2, 3 note, emergent notice.
Item 65.
Same order. Yes.
Item 66.
My lord, on behalf of SS Parida, I am submitting, my lord.
Yes.
My lord, these batch of cases are covered by the this order of writ petition, man. The subject matter of this petition is similar to this petition.
This is also university.
Interim order, yes, issued emergent notice. You are not party.
One.
OP number, AGA, Mr. Behura accept notice for OP number 1, emergent notice to OP number 2. Learned counsel Prasad appearing for the counsel on record for the petitioner submits that this court has already granted interim protection in WPC 31883 of 2025, and therefore similar protection needs to be extended to his clients in terms of interim order dated 12/11/2025 made therein. First, he has also placed at hands a copy of the interim order. First off, there is force in the submission of the net counsel. In the above circumstances, the subject application in IA number, so having been favored, there are 3 IAs. Favor. The petitioner shall be continued in service with the same terms and conditions until further orders.
Deeply obliged.
Item 67.
You can call these matters along with that WP.
67 and 68
are
similar to 64.
Correct. This folder. Similar to 64
notice.
64.
64, 65. This is notice.
This
University.
All right.
Item 69 has been disposed of. Item 70.
Item 70, my lord. After the death of the husband, the petitioner of the wife has submitted an application for appointment under the rehabilitation assistance scheme, my lord, in January 23, and that is still pending. You know, direct to take a decision.
Any proof that you have given that application?
Yes, Annex 2, my lord. They have also conducted, they have also collected Annex 2, my lord, at page 10, and that was also forwarded by the OP number 4 to OP number 3 under Annex 3, which
petitioner widow's application for appointment on compassionate ground in terms of rehabilitation scheme having not been considered despite long lapse of time, this petition is presented. First, learned counsel for the petitioner submits that the apex court in a category of decisions has held that claim for compassionate appointment should be treated on work footing, and therefore intervention of this court is warranted. First, learned AGA, Mr. Behura, on request appearing for OPs, very fairly submits that you would instruct which OP?
OP number 3, that pending with OP number 3, madam.
OP number 3 to look into the grievance of the petitioner at the earliest if all contentions are kept open. First off, this is very next paragraph. Atrix. Open to solicit information.
Might some more time, maybe.
3 months.
Item 71.
Already 1.5 years over. These are for widows, children of deceased employees, so that they should not be driven to street. Yes.
71 covered by Saraswati Bhai case, my lord. Yesterday's item 57.
Yesterday item 56.
77.
Today also. 77.
Today also.
When appear, na? When appears. You have rectified that one? Same order.
56.
I think 60.
57. 57.
57. Order as in 57.
Yes.
Item 72.
72, representation of the petitioner has been rejected. The
That in the case of Chittaranjan Das case, Lordship has already issued notice in similar cases.
The DG requested to accept this for OPs. Call along with
1 and 2.
number
1 and 2.
Yes, that all. Call which is the corrected matter.
Connect to WPC 35683
of 25.
25. Day before yesterday matter.
Next.
74 is also same.
Same.
74.
Item 73.
Item 73.
Ashok Kumar
Mahapatra. Similar matters on 73 and 75. I have given the serial numbers. 73, 75, 76, 78.
These serial numbers?
Yes, sir.
Same order.
And also,
Just say number, just you say.
They are given they were typed a type P.
Yeah, type it, but can you just tell the
73, 77.
77.
No, sorry, 73, 75.
Slowly. 73, 75.
76. 78, 79, 81, 82, 83, and 93.
93 also?
Yes, ma'am.
Okay.
I mean, parallel 110 or Hemant Chowdhury?
110. Give them.
110. Hemant Chowdhury.
I believe all your lawyers, members of the bar.
Yes.
I believe that I will not be misled. Okay.
Always.
But once I start doubting, then you will have difficult time.
No, that will not be happened. Always.
Yeah.
Item 77.
Mr. Chand, I prefer next week.
Next week. Vacation begins now. After vacation. After vacation. That's the request. Okay.
Item 78, 79 has been disposed of. Item 80.
80 minor, this is Hemant Chowdhury, that conditional order. Subject to it appeal.
Yes.
81, 82, 83 have been disposed of. Item 84.
Issue emergent notice. DG accept notice for 2, 3 and 4. Then emergent notice to 180.
Item 85.
Petitioner was working as an assistant professor, my lord, since 15th March 2021.
321.
15/3/2021, my lord. Challenging the advertisement where a condition was there for
Similar matters are yes.
85 two matters are there. My lord, 85 two matters are there.
Both same.
I've corrected 2 copies, man. And 86 also same, I have also corrected. Same
86 are connected.
Same university.
Item 87.
87, 88, 89, and 90. Covered by Loknath Behra.
88, 89,
87, 88,
89, 90.
89, 90. Covered by Loknath Behra.
Next.
Item 91.
Yes.
The petitioner before your lordship is telecom infrastructure provider. They execute.
What is that 4925 letter?
That is a additional charges which has not been there in the agreement. That is now being charged upon the petitioner.
Take emergent notice.
I have already served a copy on the council who is appearing for BSNL, Mr. P.R. Barik.
Issue emergent notice. DSG appears. DSG. There is a panel council or a different council?
BSNL. There is a BSNL council.
The learned BSNL panel council, Mr. So and so, is requested to accept notice for all OPs.
All OPs.
I will consider your application after notice service. Any difficulty?
In the meantime, no coercive action.
Petitioner draws attention of the court to IA number 543 of 2025, supported by an affidavit whereby he seeks interim protection against coercive action pursuant to impugned order dated 4/9/2025 at an exact 2. First off, matter requires deeper consideration. First off, in view of the above, with the application having been favored, the coercive action pursuant to impugned order at an exact 2 is hereby stalled till next date of hearing. Yes.
Item 92.
92, madam, the second level litigation. Now they have rejected the claims. Now similar matter also already issue notice.
Issue notice?
Yes.
Issue notice. All along with the he accepts notice for OP. All along with WP number.
Item 93 has been disposed of. Item 94.
The second journey of petitioner number 1, to your lordships, is the lessee in respect of a property in Bhubaneswar which has been leased out to him for a period of 90 years. The lease deed contains a covenant that if he wants to transfer, he has to seek the permission of the lessor.
Lessor's permission is necessary.
Is necessary. And for that, he has made an application. He has deposited a fee of rupees 15 lakhs plus. But the authorities sat over that. They did not accord him the permission, for which he travelled for the first time to your lordships.
We directed consideration.
Your lordship directed.
Now rejected.
They have rejected.
On what ground?
That he did not say anything. He's a Parkinson afflicted person. That order, my lords, is at page 32. Kindly take the last 2 paragraphs of that page. Hence, Dr. Nurul Amin, petitioner, in course of personal hearing on 12/11/25 in presence of law officer, concerned dealing assistant SN Mahanti and Afsana Saeed, I was opined, consented, able to speak, expressing his intention to transfer by way of gift in favor of Afsana Saeed. In view of the aforesaid, I am of the considered opinion view that permission sought for transfer of so-and-so by way of gift to so-and-so cannot be considered. Accordingly, the undersigned, the obedience of the order of the Honorable Court, dispose of the representations. Just because I had come to the court, they have taken it as an affront, it seems. And I'll take out notice for it.
One minute. I am for what? 1 and 2. Only one. What they have the emergent notice 2 and 3. Is it by way of Hiba?
No, not Hiba. He wants to give execute a registered gift deed in their favor.
Okay.
Not Hiba.
Next.
Item 95.
Your lordship may fix a short written about it.
No, how can I fix it? Let notice post immediately after the post.
Problem.
Item 95.
Yes.
The petitioner for your lordship has been a cricket club who my lord held various events in the locality, that is Kondapra. Here, my lord, my grievance is this. Your lordship will see there is a Madhuban playground. It has been recorded in the ROR also at page 10, which is in Odia. But my friend will also confirm that it's the land in question has been reserved for Madhuban playground. And the photographs I have enclosed also shows that it's a playground. Now we applied for holding of a cricket tournament in the playground in question. Now what they have done?
Playground means public playground.
It's a playground accessible to all.
Is there any suppressed in Karnataka? We have a playground act.
No, it is not like that. Only revenue authorities, they give permission because they are concerned with the property. Every property which is of the government is concerning the revenue department. Yeah. And the collector and the persons below collector grant permission like fire safety, electricity and other things, they grant permission. Now what they have done, they have, our application under Annex 2 is pending. Okay. Now they have given it for holding of a Mohotshav on a playground. They can do it on a gochar land or any field, that is different. On a playground, if it is done, the playground will be damaged. But it's also, there is a cricket pitch and everything that the various tournaments are being held.
What for they have?
That is a festival kind of thing which will damage definitely the field. Your Lordship will see.
How it will damage?
And our case claim has been ignored completely.
That is another thing. The ground which you are urging is not a legal ground. Assuming that it is true, it is their property. They want to do whatever they want.
And they have earmarked it for playground, and that is reflected in the record of right also. To fortify that aspect of the matter.
Playground,
yes,
festivities can be permitted.
And they have given it for the period from 17/12 to 31/12. We requested to have the tournament from 26/11 to 25 December. But if they can even give it before 17th also, we can arrange and make. But they are not listening to our Annexure 2 at all. There is no response.
To take notice.
Yes. Yes, madam. Prior to this, the OP number 5, OP number 4 applied, madam. And they have been earlier applied.
And they have been given from 17th onwards. That is fine. But so far as from 21st to 16th, they can give it for the cricket tournament. There will be no harm.
Have you stated in your application that way?
No, we have stated from 25 November to 25 December.
Now that
if they give an opportunity of hearing, we can also say that, my lord, to them. But they have already granted, they may not disturb that.
Consider the representation application.
Let's see. Annexure 2 is the...
Without interfering with the festival period.
Whatever is already granted to them,
they have created in October.
Yes. Consider their application.
Yes, that much.
Short grievance of the petitioner as sought to be made out by the senior advocate appearing for the person on record. If there is no non-consideration of the application dated
11/11/2025,
a copy whereof awaits under Exhibit 2, wherein they have requested for permission to organize a state-level cricket tournament on the playground in question. First, the senior advocate submits that the said application have been kept pending, whereas application of OP number 4 has already been disposed of favorably
by the Annexure 3, madam.
Annexure 3.
Learned Counsel also very fairly submits. He does not want to disturb the grants made in favor, the grants of permission made in favor of OP number 4, provided that the application for the remainder of the period is considered in accordance with law. First, with this proposal, the AAC is in appearing for OPs, one partial OPC is agreed. First term. Next paragraph. In the above circumstances, petition is disposed of. Directing OP number 3, madam.
2, your lordship may say 2. Your collector is the top of revenue.
Consider the subject to whom you have made the application.
I have made the application to
3. The OP number 3. To consider petitioner subject application immediately, after giving an opportunity of hearing to the petitioner. First, it is made clear that the permission already accorded to OP number 4 is kept intact.
In fact, they are saying my application is subsequent. There is another matter before lordship where they have allowed the subsequent applicant, our they have rejected. For consideration,
they will say your application is earlier application.
That is because of other considerations, which we cannot demonstrate.
But my lordship, annexed, I have pointed out that.
Yes.
Item 96 has been disposed of. Item 97.
See, Mr. Mishra has to satisfy the court and he has to satisfy the onlooking clients also.
No, clients are not here.
He makes some submission.
No, I never call the clients to the court because I feel this with lot of discomfort if the client is present. I make them one whenever client requests, I say don't come. But if you have trust, give us, otherwise don't give.
Yes. My lord, in this petition, my lord, petitioner challenged the letter dated 10/12/2025 and 31/10/2025 passed by the DO, that is opposite number 4, to replace my post without any. I am working. I am a president. I am a president in the school to replace our headmaster in charge in his post. That this fact is, my lord, is after on 29/20/36 to 2024, one headmaster retired. Thereafter, a managing committee
notice.
That is, my lord, my salary should be.
Let us not. He is the president.
President.
Is for peace.
My lord,
Call immediately.
my lord, interim order.
What interim?
Interim order. My salary. So my headmaster salary will be stop with the DO, my lord.
Let us see.
Yes, my lord. 24, my lord.
President of the managing committee has filed. my lord.
Interim application will be considered in the next date of hearing. Okay. Yes, brother.
Item 98.
Here, my lord, against the violation of the interim order of my lord, I have filed this contempt application. The writ petition is pending. 10/10/25 order. I have annexed as page 9 of the petition. My lord, I have directed in the above circumstances, application is allowed. The impugn order is stayed with the direction to extend the benefit of the office order dated 26/8/25, Annexure 14, as before during the pendency of this petition and subject to the outcome.
Application is
That
allowed.
payment has not been made.
Stayed with the direction to extend benefit of the office order dated so and so. As before during the
Yes,
pendency.
I was granted the benefit. That was with
Case for
my lord, university, that Ravensa University. Here at Kutch.
to take notice. My issue police notice to OP numbers 1 and 2. 1 and 2. Yes. Returnable within 2 weeks.
Item 99.
Your Lord, I have a piece of land under Annexure 1, your lordship, over which your lordship I am taking bank loan and I am doing a fertilizer business, construction house, your lordship. Now the opposite party, your lordship, without inserting the law under Land Education Act, your lordship, they possibly intend to take a road over the said land by making stacking raw materials.
Take notice. Take notice. Issue notice. Government is requested to accept notice for OP numbers 1 through 5, 6. 1 to 5.
One is private operator contractor, your lordship. So far 6 your lordship speed post notice is necessary.
In addition to take the usual process. Speed post notice.
The purpose, my lordship, will such because my business unit is running over this land, your lordship.
No, yes, sir.
The fertilizer business, I have taken a bank loan that they all record, your lordship. Our investment more road there.
Application will be considered on the next date of hearing. Yes, next.
Item 100.
May I please?
Yeah.
The petitioner seeking enrolled himself as an advocate under the State Bar Council ordinance. But here, the petitioner seeking enrolled himself as an advocate under the State Bar Council, but the Bar Council refused to give him an application form on the ground that the petitioner is not securing 45% on the graduation level.
Whether the 45% is a minimum requirement.
There is no provisional rule, your lordship.
There is no such rule.
No such rule, sir. Only rules is there under the
But all substandard candidates come and join the bar. Will not bar be filed?
Lordship, the
Because we have to draw the judges from the bar only. They don't come from heaven.
No.
So again, substandard people becoming lawyers, substandard people becoming judges. What will happen to the consumers of justice?
No, your lordship, subsequently the petitioner admitted and get 51% on the LLB courses, 3-year LLB courses. When he went to the Bar Council for applying, enrolled himself as an advocate and purchase application form, the Bar Council refused on the ground that you are not eligible because of you are not securing 45% on the in graduation.
To take notice, let us issue emergency notice. AG is requested to accept notice for 1. I am one. Issue.
Emergency notice to occupy 2 men. OP chairman statement.
Next.
Item 101 has been adjourned. Item 102.
Petitioners are the purchasers of the patch of land, and they are using plot number 1 to 56 and other plots as the easementary right. And they purchased the land from the mother of OP number 7 to 9. In the meantime, last settlement, the road has been developed by the NSC.
On what land?
It is
developed on which land?
On that land.
On that land means in respect to which you have.
Yes.
But you are not the owner of that property.
No, but in cell deed, the land has been appended to the map. I appended to my cell deed.
that road has been given as road, approaching road.
Who gave that approaching road to you?
My vendor, my lord.
What is his title to give that road to you?
My lord, it is
that quad non-habit is the principal.
My lord, the mother of OP 729 sold away the land to the present petitioners, showing in their sale deed that they should have approach road from the plot number 1256, 1265 and 1261. Now, my lord, 1256, what happened in the last settlement hour, the name has been recorded in the name of private person. And now, my lord, lots of time page 42. Page
Correct,
42.
but these are all civil disputes where you should go to the civil court.
My lord,
We cannot
my lord,
decide on.
we put for the grievance before the authority. Authority made a joint inquiry. Now, my lord, without taking any final decision, that's page 42, my lord, the inquiry report. Page 42. It is ascertained from the local public that the said land was used for public purpose since long, and also indicating a symbol of road in the cadastral map and connecting from National Highway 350 to Electric Office Road, having width of near about 20 feet. On the said road, NSE Khariar also constructed CC road from BRJ fund. When NSE is constructed, on the basis of wrong.
How can we all decide all these things? How can the authority decide? You go to civil court.
It is the property of the NSE. NSE is developed.
Right?
NSE is developed.
If you have any grievance, the disputed facts, all these facts, how can writ court decide these things?
My lord, we are wrestling the action of the executive officer. Let the executive officer take a decision, not to direct. Let the executive
Where is the power to take that decision? That decision they cannot.
Because, my lord, they have already acted upon all my grievance and made a joint inquiry.
Grievance of the petitioner involves disputable facts which can be adjudged only in a regular route in the light of public court decision in Dhulabai versus State of MP AR 1969 Supreme Court case 68 Supreme Court case 79 something like that. Which is a judgment. By judgment decision, all grievances should be worked out by before the civil court under section 9. 69 page 78. Page 78. First, in view of the above, petition is disposed of reserving liberty to the petitioner to undergo his grievance before the civil court. If grounds do exist, therefore, all conclusions can close. Next.
Item 103.
May I please, Your Lordship? The petitioners have been restricted to use the public dual and not allowing you to go agricultural land. In respect of the same, he has earlier filed a writ petition before this Honorable High Court, and the Honorable Court has, by Annexure 10, directed for the inquiry, and the inquiry has been made by Annexure 14 at page 61, my lord. So, on the help of the police, he has discriminated his mother's dead body, and police also interfered, but thereafter again they restricted, and in respect to the same inquiry has been made by Annexure 14, page 61, your lordship, kindly have a glance. The private opposite party 5 to 8, being a headman of the village, are quite prohibiting me to use the public tool and public institution and others, and keeping me isolated from the village.
So take notice. Okay.
Item 104.
My lord, at the same time, police may be protected for not using the.
Let you move after service of notice close.
Sir, sorted may be fixed. Otherwise, I will be prejudiced.
Go to the first day. Notice for 1, 2, 3, 4, emergent notice to 5, 6, 7.
8, 7, 8.
Additional may proceed the application number 22 of the service of notice. Yes, Mr.
Item 104.
May I please, Your Lordship?
103, I have received the instruction.
Let me just clarify
Yes,
what
sir.
has happened. I had applied for holding Mahotsav on a fielding question. Clearance were granted on 1/11/2025 from the authorities. Despite
any decision is taken,
no, they have already given it to the
25.
Yes.
subsequent applicants who applied just recently on
That's a separate cause of action.
Yes. So this application is not being considered.
Which application?
My application where my clearance has been granted.
Look into that. Please look into that order which he has given. pursuant to interim order dated.
Let me just.
You challenge this paper in separate petition. This court while interim order dated 12/12/2025 had said this was in the light of the prayer made in the petition. First of all, learned AGA appearing for the OBs has placed on record the order number 5651 of 2020, 5651 dated 15/12/2025, whereby the interim order has been complied with. First off, as a consequence, the petition has become infectious. First off, and accordingly is disposed of. We will be reserving liberty to the petitioner to lay a challenge to the order dated 15/12/2025 if he has any grievance. In that connection, all contentions are kept. Next, obliged.
Item 105 has been added. Item 106.
What is this? None appears for petition. All application. Yes.
Item 107.
Same order. Next.
Item 108.
I am for opposite partner 5 and 6. I filed this application because my appointment was challenged by a person who has no linkage and direction was given for consideration representation, taking advantage of that. He published entire print media and the media that Hon'Ble High Court has directed for inquiry. Your appointment is illegal. You have given a fraud document. So, my lord, that is why I filed an application.
Against whom?
My lord, against the prayer in the writ petition. This entire prayer that OP 5 and 6 appointment are illegal by giving wrong document, they have been appointed. I have given all my documents in my IA.
Correct.
My lord, now by taking order of this Hon'Ble Court, now the entire print media and the social media, they highlighted that by this Hon'Ble Court directed for inquiry, your appointment is for, you have given wrong document. Now my family members are not unable to move in a village, my lord, because of this.
Even your family members also don't even know. Take notice. If you have any grievance against that, the remedy is elsewhere.
No, I filed an IA for modification of the order, my lord.
Notice what
I filed an IA for modification order in the writ petition. Writ petition, my lord, have disposed of. I am for opposite partner 5. No notice was issued. I filed an IA for modification order and given an opportunity, my lord, that I filed.
Emergent notice. Who appears for the
petitioner, my lord? Petitioner.
Mr. Roth. Mr. Roth, HP Roth. Another Roth.
Issue emergent. Subject. Take notice on the application.
On IA.
Emergent notice on the application. Okay.
Item 109.
109, your lordship, I had filed an application for recalling the order and modification.
Lord, I am on behalf of Mr. P. K. Nanda, my lord. Let me take instruction 1 week time, my lord.
Let him come back. Yes.
Lordship, only said there in the first week.
In the second week, you can go to the second week of January. Yes.
Item 110 has been disposed of. Item 111.
11, my lord. In connected case, this is covered by Hemant Chitra. In connected case.
Connected case.
25261.
See, only connected case. And in this matter?
In this matter, I am not.
26029.
No, I am not.
That's also the same order. Sarat Chandra Parida.
My lord.
The same order, no?
So far the first item is concerned, I have filed a lit that may kind of accept.
Covered by
judgment. Same order.
Item 112.
Mr. Samal, in this case, notice has been issued to OP number 5. Notice has to be issued on OP number 5, but it is wrongly mentioned as OP number 4. I have already filed requisite note.
Notice to be issued to OP number 5. Come on, I'll say submit counsel for the petitioner. In that connection, application is filed.
Requisition is already filed.
He submits that requisite have already been furnished. First, registry to process the same in respect of copy number 5.
Item 113.
In this case, there is one letter typographer error. So I have to be 3.
You are rectified it now.
My lord, I have given filed request. Correctly. That's the thing now.
Rectification is 235527.
My lord, 1-4 given, handed over.
Correct.
And for others, request filed, my lord. Should I have this?
Okay.
Item 114.
Due to some defect, when we have not filed the requests, transfer things.
Within 3 working days. Depending on petition stands rejected. Yes.
Item 115.
My lords, 1 week more time I filed requisition.
Yes, same. Within 3 days.
My lords. 3 working days. 3 working days.
Item 116.
This code of affairs have been withdrawn.
We have already passed the order.
116 is withdrawal, na?
116 is withdrawn.
In view of the order dated 2/12/2025.
Anyway,
Fine.
yes.
Item 117.
After application.
They have not filed this. This is a fresh admission. They have not filed the limitation petition. They have filed it in the meantime.
Delayed appeal.
Delayed appeal, my lord. It is
Application is filed for condonation of delay, no?
no, recently they have filed.
No, they can file it. Supreme Court said. Subsequently, also application can be filed for condonation of delay.
Yes.
Next, anyway, let it come after vacation.
Item 118 has been adjourned. Item 119.
None appears for application.
119.
119.
In this case, to direct my learned friend for the governing body to produce the papers.
Governing body already
We have brought a truckload of papers.
Directed all the resolution and
We'll look into them after.
yes.
All after.
Let him produce give it flag mark so that it will be easier to see us. Flag mark.
They just I received yesterday and
In the meantime, they have sufficient time to make it.
Yes, in the meantime, let the flag mark and see it so that it will be easier for us.
yes,
To do that.
I'll prepare a chart
Yes.
according to data, all date and
The 3rd week of January 2026. Yes.
Item 120.
I prefer 1 week time to.
After vacation.
Please. I prefer my petition is very yield. He couldn't come. I will file count.
You want to file count?
Sorry, I will file affidavit. Sorry. Affidavit for stating including the DAX statements. I will file.
All after vacation, the request of Dr. Chudi.
supplemental list.
Only very urgent matters will come. Tomorrow only it works half day.
No more in service since 2020, my lord.
Nothing will happen.
I may be excused, my lord. Item number 107. I was held up in the other court. I couldn't appear on time of court. 107. There an interim application has been filed for allowing me to appear at the.
No, appears call application is already signed. Yes, next.
Already signed. I only prepared.
Urgent matter. Yeah, urgent matter, my lord. My term of appointment is going to over on 31st December. I could not make a mention because I could not get the number in the first hour. But can you check tomorrow, my lord? Urgent matter. Tomorrow.
What's the urgency?
31st December is my last date of term of appointment. On that date, I will automatically. Tomorrow.
No, pardon, my lord. Item number 62. It has been disposed of in my absence. I was earlier held up in another court, madam.
We can't wait.
I simply pray that a time stipulation will there only.
My duty is only to decide the causes that are brought before me. But I have no duty to wait for anybody.
Ground of the case,
Item 121.
Next.
Item 121.
Please find. Yes.
Your lordship,
Directed the university to produce the mark. University to produce the mark.
Yes.
University, Mr. T.N. Patnaik.
Mr. T.N. Patnaik.
His name is
Patnaik. His name is there in the order.
Cause list.
Cause list.
Cause list, his name is
In the
not.
cause list, his name is not there.
To bring the name of Mr. Patnaik.
Possibly he has missed the list.
Yes.
To the appearing person. I'm not seeing Patnaik these days in my court.
No, since last 7 days, actually he is not coming because of. We are not seeing. I think.
Other courts.
Application.
The name may be reflected in the cause list.
We wanted to continue.
Registering to print the name. Interim order is there?
In the second matter, interim order is there.
Wherever there is interim order.
Assignment changes, then it will be.
All judges are appointed by the warrant of the president. No difference. Yes.
Item 122.
Yeah.
122 and only I am for the respondent. Let it come after vacation.
Absolutely. First week of February.
First week.
Yes.
Item 123.
My lord. This case, my lord, the order of the learned tribunal is under challenge under section 24C. The fresh case, my lord. The only interpretation, though it is a voluminous brief, but only the interpretation of a particular provision of the J Order 2008. My case was dismissed. This is the case.
What is the interpretation?
Yes.
What you thought to have placed
Yes,
according to you?
kindly see, my lord, 2008 J Order. Granted order.
Education. You give our manual to them. Then
5443. 443. No, 5443.
443. Yes.
My lord.
According to you.
My lord, what the dispute is in the just there is a yardstick under this Latin order. He says if the institution have 64 seats, then only 4 optional subjects will be eligible to get the granted.
Means for one each, one for 16.
No. For total 64 seats.
64 seats.
4 optional subjects. I mean, political science, history, these are the optional subjects, madam. History, whatever the subject is. Besides the compulsory subject. Compulsory subject is the Odia, this is the MIL, and the English. That has nothing to do with this. So now, with this, my lord, we have to go to the statute, and the eligibility has been fixed. Kindly turn to my lord, 443, my lord, I have it.
443.
Yes, that Orissa Non-Government College.
2008 order.
Yes, ma'am.
Yeah. Which section? Which provision?
Provision. Kindly see the eligibility. Correct 10. Eligibility of the post for block grant. Correct 447. Page 447.
Yes.
Other provisions are, my lord. A post in a non-government educational institution for which no grantinate has been sanctioned prior to commencement of this order shall be eligible for grantinate in shape of block grant if the post is admissible as per the workload and yardstick prescribed in this order as at Annexure 2.
Yeah.
It has
completed qualifying period of 5 years or more from the date of admissibility, or 3 years more case of educational institution in the educational backward district or a women's institution. Now, my lord may skip over all of this procedure. 6. So, para 6. The date of eligibility. Next page. Other thing, according to me, not at the point. The date of eligibility of a post for which.
Where are you reading?
My lord, that clause 6 of 10.6, para 10.6.
10 sub para 6.
448.
Date of eligibility.
Date of eligibility of a post for which granted supply ground has not been sanctioned.
First date of
academic year following the date on which an approved post completes the qualifying period as applicable to the post, provided that the date of eligibility in respect of a post in an educational institution shall in no case be a date prior to
cut-off date is 2006.
2003. That is the. Now, my lord, come to the rule 19. Sorry, para 9. Para 19 of that schedule.
Just removal of doubts.
Removal of doubts. For removal of doubts, any difficult government is not inconsistent with provision of this act.
Correct.
And the rule, this order.
Correct.
These are the provisions. Now, my lord, kindly come to the yardstick. That is at 464. Again, sorry, my lord, 464 page, Annex 2. That yardstick that is referred to that. Yes. This is the yardstick.
10.6.
My lord. 10.1. That is referred to Annex 2. Yes. Yardstick for approval of post in aided education institution for purpose of block grant. See para 10. Maximum number of subjects other than the compulsory subjects in which admissible post of teachers will be eligible for approval for purposes of granting aid in shape of block grant shall be indicated in the table below. So now, my lord, kindly come to junior college. We are concerned about this junior college. Arts. 64. Actual enrollment subject to the maximum recognized and affiliated strength of the student. Government grant recognition for a particular number of seats. That is the 64. Maximum number of subjects other than compulsory subjects shall be 4. Now we have understood this man.
Yeah.
Now, my lord, kindly come to 2. 1 post of lecturer of each compulsory subject will be admissible unless more posts were justified on the basis of workload and on the basis of yardstick hereinafter provided. When the same compulsory subject is taking as a compulsory subject or optional subject, many other stream or counts courses, number of teachers will be determined on the basis of the total workload in that subject for all courses and streams taken together in the same educational institution. Next, my dispute in the next 3. This particular dispute. Where an aided educational institution has received recognition and affiliation for more optional subject as admissible on the basis of column 4 of the table in para 1, the number of optional subjects for which teachers will be admissible shall be limited to the number of indicated in column number 4. And teachers in the remaining subject shall not be eligible for approval. Next, in these circumstances, the subject in which post of teachers shall be approved shall be based on the number of students presented in the final degree examination conducted by the university or the higher secondary examination conducted by the council, or the average during the 3 consecutive years preceding the date of eligibility. The date of eligibility 1/6/2003, preceding the eligibility of the institution to be notified as educational institution. I will pause. There is an illustration. I will pause here to state the facts of this case. Here, my lord, there are more than 4 optional subjects for this institution. So therefore, which one will be the 4th one? Because 1 to 4 will get, my lord, but there are 5. So which 4 will get it?
The 5,
which 4 will get it? That is the distinction is, my understanding of this provision is, if the 3 years consecutive enrollment preceding the eligibility, whichever subject is more, he will come first. Suppose history, political science, economics, logic, Sanskrit.
Oh, tribunal they are the.
Yes, there is another clause. I will read it. Just time. The dispute is now between myself and my learned French client. I am from the lecture Sanskrit and my non-friend client is economics. So now, whichever subject has presented more students or the enroll more student in the consecutive average of 3 years consecutive to that date of eligibility, he will get, this is the plain understanding of mine from this clause. Thereafter, my lord, the confusion tribunal has caused, that comes out. Kindly turn to then 4 plus 4. Additional post. Shall I read this illustration, my lord? I have stated.
Illustration will give, it will illustrate
yes.
the provision.
Yes, a college has received recognition application for 128 seats and 6 optional subjects. The actual enrollment is 64. It will therefore be eligible for approval of teachers. 4 subjects, not 6 subjects.
But which 4?
That is the decision as clause 3. Whichever is more
number of students.
For
3 consecutive average number.
Average number. Whoever is more, then he will get first. So now, my lord, plus 4. Additional post. Here is additional post
of lecturer for optional subjects.
For optional subjects will be admissible on the basis of the workload assessed with reference to the yardstick indicated herein after for the purpose of determination of the total workload. The workload on account of the higher secondary courses and degree courses in all stream in that subject shall be taken together, provided that higher secondary wing and the degree wing of that institution have both.
There is illustration also. Go to illustration. I have read that. Go to next illustration.
So now illustration is that if this is minus only one line, I will submit, my lord. Shall I read? General college has received recognition and affiliation subject A. In subject A is compulsory subject for all students. It is an optional subject for some students. The total number of classes for the compulsory subject is 25 per week, and total number of classes in that subject as optional subject is 12 per week. Since the total workload is 37 per week, 2 teachers would be eligible for approval. 2 years later, the same institution received recognition and affiliation for opening of degree courses in arts, where this subject is taught as one of the optional subjects. The total number of classes in this subject as an optional subject in the degree courses comes to 12 classes per week. The total workload in the subject in that education institution after notification of the degree as an added institution, therefore.
How the tribunal has considered.
Yes, now 5 I will complete 5, thereafter I will come to the tribunal.
One there is a lecturer would be admissible for 25 periods.
Yet the 25 multiplication of 20% of the 25. Suppose 25, if 25 classes in a week, 1 teacher will be available.
Correct.
If it is increased by 20% of 25, that means another 5, suppose. 31, suppose it will come down 31 classes in a week. Second lecture can be accorded that particular subject. Not for an entire. And for determination, there is a distinction. But I want to make it. How para 3, yes, there is a circular. All this confusion, I have read internationally that para 19 to read of the government issued a circular that caused the ice. That I will show thereafter terminal finding. Might not have understood these provisions. Now, I'll kindly come to Annex 13. That page 72. There is a government has issued not a circular, is a letter, which has no statutory force. That create all these difficulties, isn't this?
What it said,
my lord, I'm reading it. This 3412, I am directed to say that large number of grievances are there for approval teaching post, especially in 662 category of colleges under J Order 2008, which has been held up on the ground that the institution had not presented at least 16 number of students in the consecutive 3 years by the qualifying date. After careful consideration of the above problem and in order to mitigate the hardship faced by the teaching personnel, if that has been decided, that Director Higher Education will analyze all pending cases in details. Such pending cases where all other conditions have been met, except the condition of average 16 student appearance every year, will be reconsidered.
Why it said except the average 16?
That I don't know, my lord. That is the dispute. This circular, my dispute commission is, this says nothing of the, this is conflicting to the rules. And rule 9, sorry, I'm wrongly saying the rule, para, my lord.
Correct.
The paragraph 19 says, if they can have many number of resolutions, but it cannot have an inconsistent to the parent provision. Parent provision is J Order 2008. 2008 says that it will be 3 consecutive.
Requires consideration.
That is why now, my lord, the tribunal has accepted this and dismissed my case. But the fact remains, the consecutive 3-year presentation is always above this economics, that will be, my lord, I will demonstrate from
No,
their
you are
document.
demonstrating now.
No, that is their document, not director's document.
No, that's all right. But
Yes.
I'm not disposing of the matter today.
Yes, this is fine. But now, my lord, because there was stay all through, my lord, in the tribunal. This case has come to my lord once and is remanded again. They have taken it to Supreme Court. Supreme Court didn't interfere. However, the tribunal has not passed order. If interim order will pass, my lord, then granted will be released for the other person. It has been stayed long since.
But let us see.
Yes.
That is the only point.
That is the only point. The only
tribunal is swayed away by the circle.
This circle.
That's all.
That is only point.
Let us see.
I am appearing for the private opposite party. I have nothing to say because Lordship intervened in matters. Only one thing, my lords. My lord, my appointment, I was appointed in 1993.
No, I am not hearing that.
No, I am not. My lord, just twice I have succeeded actually.
In the first week of February 2022. Yes.
Item 125.
IMN. This order may not be given, so that now other things will proceed. But two person fighting out for one set of granting it. It has been stayed by the tribunal also till filing of this case.
No, we will decide this matter and then things will follow.
Yes, but now in the meantime they may not take any further action.
Whatever action taken shall be subject to outcome of the petition, appeal.
Because earlier also this court has stated that process.
124.
Yeah.
He is there for condonation of delay.
Notice has not gone.
Notice has not gone. My lord, similar cases where my lord tribunal rejected the case on the relying the judgment.
Anyway, no condonation unless condoned. We cannot enter it in the appeal or very. So notice has not gone now.
No, my lord.
Please notice both on main matter and application. Yeah.
Item 125.
Short date.
My lord, we are filing rejoinder.
Short date.
File it in office. Yes, calling the
125. My lord, these are regulation matters, my lord.
Item 126.
125.
125 first February 26. Yes.
My lord, can I pray in the month of January?
No, not possible. Next now.
Item 126.
My lord, I am filing the rejoinder today.
You file it in your registry.
Yes,
not here. Yes.
I'll give it. I have served a copy to government. Your lordship may.
Rejoinder may be filed.
Copy served to
By
government.
counsel for the petitioner. Petitioner.
My lord.
Item 127.
That's in item number 127. The petitioner's salary, my lord, it was stopped in the month of October 2024 without any communication, without any notice, without assigning any reasons, my lord.
Some order was made.
Yes, my lords. My lords, a number of orders have been made, my lords. First of all, my lords, my lord may kindly see.
But I am not taking the matter on minutes, na. Only urgent matters alone we are taking.
My lords, this man has been going without salary since October 2024, my lords.
Anyway,
That
for
is the limited period.
last more than a year, you are.
My lords, number of orders have been passed. My lords may kindly see first order number 5, which was passed on.
We'll look into all those orders in the for the second week of January, February. Next.
Item 128.
Lords, you kindly have a glance to my lord's order dated 12/9/2025. 12/9/2025.
Why the papers are not put up on the table of the government despite the memo dated 33/25?
Are they not compliant?
It was compliant.
Now it has been compliant.
My lord, government after considering has sent back to the DO to take appropriate steps.
This was on 24/11/2025.
My lord.
It only reiterated my order. What happened next?
Next, I have sought instruction, my lord.
No, this order was made.
My lord.
Go to the order. Take out that order.
That is Annexure 6, my lords, Annexure 8. Your lordship, there was earlier order to place the matter before the government.
Yeah. Where have you placed or not?
Yes, my lords. After, this is the order of the government.
The government only says comply with this order, otherwise complications. Because they know that I'll create complication. They have said only that.
My lord,
Where is that?
now this DO will take the appropriate decision.
When will he take the decision?
They call 2 weeks after.
Learned, for this court by order dated 4/11/2024, no, 12/9/2025 had said that. First, learned AGA this day has filed, is it order or letter number?
Letter, man.
Letter number 32344, SME dated 24/11/2025, which reads as under. First one. Next one. This letter only reiterates the order of this court and nothing beyond. First one. When confronted with this question, learned AGA submits that the decision will be taken by the DO within 3 weeks. 3 weeks. First one. Believing those words, matter is adjourned to third week of January 2026. First one, non-compliance will be viewed very seriously, and costs in thousands of.
My lord, the order was to place before the government.
Where have you placed?
My lord, it was after it was placed, my lords, that is by letter dated 25/10/2025, the DO placed the matter before the government, my lord.
And now government DO will take the decision. Therefore, I have written that. If it does not take,
so my
then
lord,
these things happen.
my lords, there is no order to comply. That is what I.
No. Question is, what for you will place the papers on the table of the government for taking decision? Certainly for not anything else.
My lord.
That decision has to be taken. That is his papers.
My lords, the order was to place before the government.
Correct.
It was placed on 25/10/2025. Now the government has
sent it back to DO. Yeah. What DO should do now?
Now he will take the decision.
That is what I am writing. Within what period he is taking? Next day, if he does not do, I will summon the DO. Yes. Viewed very seriously. And personal appearance may be directed. Yes. Government officers should work. That's all. Simple. You can't just, yes.
Item 129.
In 129, I pray for 2 more weeks time, my lord, to file a detailed counter affidavit.
Filing counter, my lord, my interim application is pending. Similar matters, your lordship has passed an interim order.
In this case, I humbly pray, my lord.
This is the similar matter, your lordship has passed interim order. If your lordship kind enough to.
Interim order is granted in
yes, other matters.
Just show it to your friend. He is very fair. I've seen him in many matters. If interim order is granted, then
in other identical cases, but this case only, actually, my lord, what has happened?
You, in the meanwhile, let there be interim order. You take 4 weeks for filing the counter.
And my specific instruction is there has been no deduction so far. No penal action has been taken.
No penal action is taken.
Taken so far.
So far. Are you going to take?
No. There is no. Because
I record your submission.
Kindly record, my lord, because this is the case that 100% utilization is not being made of the transporting vehicles. Here, he is helping the Federation, my lord, in utilizing to the extent 100%, my lord. So, therefore, no penal action so far has been taken.
Your lordship has only said no coercive action.
The learned counsel for the petitioner's versus the application for interim protection. First, learned panel counsel appearing for the
Milk Federation.
The Milk Federation. Having opposed the application, very fairly submits that till date no court's action had been taken pursuant to impugned order, and therefore petitioner need not have the apprehension of any such action being taken before long. First one, in view of the above, call this matter in the third week of January 2026. In the whole way, counters may be filed. Yes. You are protected now. Yes.
Item 130.
Already compliant.
Compliance.
Already compliant.
Compliance reported, registry to verify. Next.
Item 131.
What is that personal appearance?
My lords, that correction of green card.
That has been done now.
Yes.
Then the matter has become infectious.
My lords.
Good. This court wide interim order dated so and so. Go to that order. Date 16/12/2025 had said as under. Learned AGA very fairly submits that the petition itself has become infructuous since the relief sought for by the petitioner has been granted. First off, with this submission, counsel for the petitioner also is agreeable. First off, in view of the above, petition is disposed of accordingly. Next.
Item 131.
May I please, Your Lordship?
Yes.
Here the defendants, unsuccessful defendants, are the appellants before my lord, challenging the reversing judgment of the lower appellate court.
Judgment decree dated.
Pardon me, Lord?
Judgment and decree. Appeal is against the decree.
Against the judgment and decree.
Appeal lies against the decree.
Yes.
Anyway, which date?
Yes. That is the plaintiff suit was one for recovery of possession simpliciter.
CS number?
Case number is, I'm just giving, 60, title suit 61 of 94.
61 of 94. Title suit?
Pardon me, Lord? Title suit.
Title suit?
Yes, title suit.
But you said injunction simpliciter.
Pardon me, Lord?
You said injunction simpliciter.
Recovery operation simpliciter.
Recovery of?
Possession simpliciter.
Okay. You are defendants.
Yes. That was subsequently title suit number 39 of 96.
It was renumbered.
Yes, renumbered.
As a CS?
No, TS. Title suit.
Title TS.
Then it was TS. Now it is CS.
Now it is CS.
At present it is CS.
TS number?
Title suit number 39 of 96.
Yes. What the trial judge did?
Pardon?
What the trial court did?
Yes. Should I place the plaintiff's case and defendant's case thereafter?
Just I want to know.
We'll go. Yes. Yes.
The
The trial court framed as many as 9 issues. The first issue was whether it is joint family property belonging to both parties or it was self-acquired property of the plaintiff, basing on the strength of a cell deed. That is Exhibit 3.
Exhibit 3.
Yes.
Cell deed is of which year?
That is sometime, I'm just 55.
And in whose name?
That is.
Whether as on that date family was nuclear family or the joint family at that time?
Yes.
That is the issue.
Then that is one issue. And it was answered that it was the self-acquired property of the plaintiff by the trial judge.
Which is that cell deed?
Cell deed is Exhibit 3. That is 3595 dated. 3595.
In whose name it is? Cell deed stands in the name of?
Cell deed stands in the name of the plaintiff. In favor of the plaintiff.
Yes.
By one Bhagavan Behra. Bhagavan Behra is the executant of the cell deed.
No, executant means he sold.
He sold. He is the transferor. Bhagavan Behra is the transferor.
He was the original plaintiff. He was the original plaintiff.
No. Let me. He was the transferor. So far as the cell deed is concerned. He transferred this property to this plaintiff. Present plaintiff.
Correct.
Because originally that Bhagavan had filed a suit.
Before transferring?
Yes, before transfer. And during pendency of that suit, transfer was effected.
No, that suit for what?
That was for injunction.
Injunction?
In simpliciter.
The injunction not to
against the present defendants. Against the present defendants. Thereafter, he died. And this purchaser stepped into the suit. And the suit was renumbered. For that reason, suit was renumbered.
It became titles.
Yes. It was before the civil judge junior division earlier.
Then it came
And it came to the senior division judge. Civil judge senior division. Banjanagar. So the suit was renumbered. Then the next question is, the defendants claimed, defendant number 1 claimed that he is the adopted son. He was given in adoption by his natural parents to this Bhagavan. Bhagavan means transparent.
Original transfer. One who executed the sale deed.
Panmila?
One who executed the sale deed. Bhagavan is the seller.
Seller, yes. Seller. He adopted this defendant number 1.
He adopted
in 1974. Sometime in 1974. That was the case of the defendants.
What was the age of the defendant as on the date of adoption?
That is 15 years.
15 years.
Yes. That adoption took place in 1974.
Any deed? Any deed is there?
No, deed was not there. Deed was not there. Only oral evidence has been adduced in support of the adoption. Then, on that score, the trial judge has held that adoption has not been clearly established. That is the finding.
But for adoption, proving in adoption,
yes,
means on Hindu law says there should be a
giving and taking.
A dattaka homa. That's one.
Giving and taking.
Dattaka homa.
Yes. That is there. That is there in evidence.
Accepts.
Yes, that is there in evidence.
Who gave that evidence?
That
PW?
Natural parents was not there.
No. The others who attended the ceremony, etc. at that time.
Evidence that the defendants has given evidence.
Who is that? DW?
DW1.
DW1 speaks on adoption.
Yes. Adopted son.
DW1 is defendant himself.
Defendant number 1.
Apart from that, whom he examined to prove the ceremony?
Ceremony.
The giving and taking ceremony has to happen. Who was the priest?
No priest. Priest has not been examined. Priest has not been examined.
Fault in that.
Not been examined.
Then how can you falter the finding of the court below?
But there is evidence that he was taken in adoption.
What is that?
Giving and taking was there.
Only said giving and taking. Where are the witnesses? The adoption, it's a family ceremony. But at that time, who were present?
Yes, your lordship.
The occasion arose for taking adoption. Why only this man?
Yes, your lordship is correct. Correct on that.
That evidence has Bombay High Court judgment, Justice Chitale's judgment. You can't just say that I have been taken in adoption. That will not help you. Because you are in second appeal now.
Yes.
What is the substantial question of?
Yes.
What is the substantial question of on which appeal?
That your lordship finds on the order. And just please
go to substantial question of law. Mr. Mishra, what are the substantial questions of law?
Substantial question of law.
2 questions have been formulated.
Which are those questions?
That is, your lordship may see
order dated 22 and 24.
Yes, your lordship.
22 and 24.
22/1/2024.
Yes.
Order dated 22/1/2024.
Where are the questions?
Order number 13.
Whether the prayer of the plaintiff respondent in the suit by title should now 36/96 for recovery of possession of the suit properties from the defendant appellant without any prayer for recovery of
maintainability of the law.
Yes, that is one.
And whether during hearing of the first appeal, defendants can argue challenging the adverse finding in the judgment of the trial court made against him without filing
any cross objection.
Because the findings are against him.
Number 2, what the court, first appellate court said? The second question has to be answered in his favor.
Yes.
They need not for challenging. See, appeal lies on a decree.
Yes.
If an adverse finding is suffered, in an appeal which you may file, he can attack the adverse findings. Order 41 Rule 20.
Yes, 20, yes. 25.
25.
Yes.
Order 41 Rule 25. Give that.
Order
FAC.
Order 41 Rule 22 is cross objection. 22
No, without filing cross objection.
That is 25.
25.
25 or 31?
24 or 25?
Your Lordship is 31 perhaps. I may not be wrong. No,
not 31.
25 is remanded.
Give them the opportunity. Take out and give. The famous judgment of the apex court, Order 41 Rule 25 26, said without filing cross objections, the other side can show the findings of the court below are wrong, which is that judgment. There is apex court judgment by Justice G.L. Ojha. It's a concurrent finding.
No, not concurrent.
Divergent finding.
Trial court gave a finding that adoption is not established, and also it is a self-acquired property. So those, but said that cell deed has not been executed properly. So we dismiss the suit based on that only.
Disbelieve the cell deed.
So appellate court
execution of cell deed was not held to be proved.
Yes.
So that by trial court.
No compulsion of consideration.
Appellate court said that no, cell deed has been executed properly and allowed the appeal.
Lordship said Rule 33. I am not wrong. Rule 33 will.
Rule 33.
33.
The power of the appellate court to pass any order or decree is another thing. No, there is one order, which is that order.
And I have brought a decision on that score. That is 99 Supreme Court. You will also see this. 99 Supreme Court. Page 3571. That is M. Jagannath Rao case. That is Ravindra Kumar Sharma versus State of Assam.
Order 41 Rule 22 will be the appropriate here.
22.
Yes,
22 is cross objection.
No, cross objection. It is also there.
Object to decree.
Yes. Any response
As if we had preferred separate appeal.
May not only support the decree, but also may also state the finding against him and the court in respect of an issue.
Order 22. Order 41 Rule 20.
It is cross objection here.
And may take
judgment.
and also may also take any judgment which would have taken by appeal, provided he has filed such objection.
And this decision of the apex court I have brought.
Explanation is that respondent agreed by finding of the court in the judgment on which decree appealed is based on this filing
cross objection in respect of the decree so far as it is
based on the finding, not reasoning that any region.
No, this has been interpreted by the apex court saying without filing the cross objection, he is entitled to attack the findings of the court
against
in your appeal.
Yes.
In your appeal. That is the law now.
Yes.
Pannala was the state of Bombay. Now I am asking you now, whether adoption was there or not is a question of fact. At least mixed question of law and facts. But second appeal lies purely on substantial question of law. And the first question as to the maintainability of such a suit. On that, what is your material?
I have brought a decision. Yes, Lord. Your Lordship may see para 17.
So, first is concerned, there is a prayer for recovery position. So the first, by amendment of the plaint, recovery position was prayed for, and that is the decree of the appellate court also, that is the decree.
Yes.
So the first should be against the appellant, because there is no such, there is no, section 34 of the provision of this specifically fact, but that application has no, that provision has no application, because there is a prayer for specific recovery.
Therefore, first question will not arise. Where are your substantial question of law in your appeal memo? The first question will not arise because there is a prayer. There is a prayer for decree of possession.
And that is the decree of the appellate court.
In your appeal memo, what are the substantial questions of law you have raised? This question will not arise at all. Under amended CPC, you court can say that these substantial questions of law will not arise at all.
Yes.
Then you may frame other substantial question of law.
Can be taken up at the time of hearing?
No, I am hearing you now. This is second appeal.
Yes. Your Lordship may see para 17.
Para 17
that answers the first substantial question of law.
Go to
where a cloud is raised over plaintiff's title and he doesn't have possession. Here he doesn't have possession. A suit for declaration and possession with or without consequential injunction is the remedy.
That question will not arise because he has sought for a decree of possession. He has amended.
Yes, not amended.
Yes,
amended.
Where is your plaint?
Not
amended. Kindly see the plaint.
Read plaint prayer.
The plaint.
Because no amendment is there in the...
Yes, my lord. My lord, probably. My lord, kindly see the prayer. To pass a decree for recovery of possession of the suit house from defendant number 1 and 2, or from persons claiming through them, put the plaintiff in possession of the suit house. Because the case was that during pendency of the suit, they forcibly entered into possession. That is the
suit prayer was amended.
Prayer was amended.
Not amended.
So because
they have not sought declaration of title.
The question is
because there is no denial of title. There is no denial of title. No,
because defendants claim title by prescription.
The original plaintiff, Bhagwan Behra was the original plaintiff. My lord friend may correct me if I am wrong. Bhagwan Behra was the original plaintiff. He filed the suit for permanent injunction against those the persons, against the dependents, saying that they are disturbing his possession. So during pendency of the suit, he transferred the property in favor of the present plaintiff. What happened is Bhagwan Behra died during pendency of the suit. So during pendency, Bhagwan Behra died. The present plaintiff being purchaser, he stepped into the shoes of the plaintiff. That is how the suit continued, and this is how the prayer. So that is so title. What is that depends on the original plaintiff, because the substitute plaintiff can only put into the shoes of the plaintiff, original plaintiff. So what happened? He had not challenged the title of Bhagwan. He said that no, it is a joint family property. The property which is claimed is a purchase of the joint family property, joint family nucleus. So it cannot be exclusive property. That was so he had not challenged the title, and also stated about the case of adoption. And also
execution.
Then secondly, he said that the defendant number 1 is the adopted son of the plaintiff, original plaintiff. So that was the two defense he has taken.
And adoption is not true.
Adoption is because Dottama, your lordship rightly said, Dottama trial court has categorically come to a finding that there is no evidence at all. Even defendant number 1, DW1 also admits that there is no priest, there is no there is no, he was 15 years old.
Where is no, up to 15 years old they can be.
Yes,
in your state, there is one judgment of apex court.
Yes.
which said even after 15 years it is.
No, I do not say that. He cannot be adopted. I cannot say that is not my case. They say that
There is
he
no
was
adoption.
15-year-old and he was not.
Go to your
Other witnesses have not been
Go
found.
to your pleadings relating to adoption. In adoption, about adoption.
Pleadings.
What have you stated in your WS?
And in the school shipping certificate, all the documents have been considered by the trial court. Your Lordship goes to the trial court judgment, or will get it.
No, one second. Let us see.
Yes, madam.
Now, I can frame other issue.
Yes, madam.
Substantial question of law.
May permitted to placement?
No, just what is the pleading
Yes, sir.
relating to
He
these
is pleading only. He is pleading only, I'll place.
Yes.
All right, you place.
Yes.
Please.
Anybody.
You place any.
Allegations in the plaintiff that suit house is the self-acquired property of the plaintiff is not true, but he has never due and never occurred in any loan from Sudhi of his wife for
Regarding adoption.
regarding adoption. Is there your letter?
Lordship wants
Regarding adoption, yes.
regarding adoption only.
Regarding adoption,
What are the pleadings on adoption?
regarding adoption, he has said.
If adoption is not proved, then rest of the issues will not arise at all. He will not have locus standi itself. If locus standi is only if adoption is proved. Otherwise, who are you to this property?
Para 5 Malad may kindly permitted. The plaintiff had no issue and thus he and his wife were loving much to the defendant number 1 since the childhood to take him as their adopted son and had requested to the parents of the defendant number 1 for such purpose. He had agreed for the same. Hence, when the defendant number 1 was about
1 second. Requested different
parents of the
Natural parents.
Whether parents were alive as of the date the evidence was given.
No.
They were not alive.
No.
You have stated they are dead. Then where it happened?
Then when the defendant number 1 was about 15 years old at the month of Vaisakha Shukla Dasami, day of 74, both the plaintiff and his wife asked to the parents of defendant number 1 to give defendant number 1 as his adopted son in presence of close relations and street people in
Any
the
close
house of-
relations were examined?
No, they are not examined.
Not examined.
No, the other DWs have not stated anything out of adoption.
Who spoke about adoption?
Only DW himself. Only the person who claims to be the adopted son, he only spoke about.
One second. Mr. Mishra,
sorry,
1 second. Any explanation is given as to why no relative is examined?
No, he is not offered in the exam.
Any offered examined in the
No, he has not offered any explanation.
They are dead, they are gone abroad.
No, they are not.
They are very
He has
aged,
not
they cannot-
offered any explanation.
Anything has been stated?
No, that has not been stated by DW 1. And is that the further presented to give defendant number 1 to the adopted son in presence of close relations and street people in the house of the plaintiff.
Street people also.
Street people also and parents of the defendant number 1 gave the defendant number 1 to the plaintiff and his wife, and thus by such giving and taking ceremony the adoption was completed, followed by feast held by the plaintiff to mark this occasion as per their local custom, and they belong to scheduled tribe. Thus, since the defendant number 1 lived with
They are scheduled tribe. Whether to scheduled tribes Hindu Adoption and Maintenance Act applies?
No, that is not. But
to
that
marriage
will be
act-
governed by the custom. They will be governed by the custom. The custom has to plead it specifically.
Therefore, I am asking you, first is whether scheduled tribes have, whether the Hindu Adoption and Maintenance Act applies to scheduled tribes.
Yes.
Or customary Shastric law of adoption applies to scheduled tribes. It does not apply.
Because the treated as
Seller is a scheduled tribe.
Scheduled tribe.
Adoptive father.
Yeah.
I mean.
Adoptive father is
dead.
No, he's dead. He is also scheduled tribe.
Yes.
Scheduled tribe.
Yes.
And the defendant number 1?
Defendant number 1 is scheduled tribe.
He is also scheduled tribe from the same tribe.
Yes.
Any relation?
Yes.
What is the relation?
He is the nephew, brother's son.
Brother's son.
Yes. It is joint family property. For that reason, they say joint family property. From income, it was acquired. The property was acquired. That is the case. And sale deed has been not accepted by the trial court. Executions and there is no consideration has passed. And no delivery of possession.
No, that
all those findings are there.
That question arises. That is, sir. that question arises only for an adopted son. The whole case depends upon adoption. Once adoption is proved, then the other question arises whether the property is a joint family property or self-acquired property of the plaintiff. Otherwise, we need not travel to the second question at all. Therefore, because in the absence of adoption, you are a stranger to the family. Therefore, you will have no locus standi to challenge the sale deed.
But here that question has not been taken up by the appellate court, saying that there is no cross objection. You want to appreciate. So the question of fact, the lower appellate could have gone into that.
Trial court finding evidence is there on record. Trial court finding evidence only.
By the lower appellate court. On that score, even an adoption.
All right, we'll now look into what is your evidence. Read it. Your pleadings are insufficient. Your pleadings for adoption are insufficient. For adoption, you have to plead because you say according to custom applicable to the community.
Yes.
To say that there is a custom, at least one or two witnesses should have been examined from the village, elder people. Yes, in our community, the adoption is followed. This is the procedure. Mr. X had adopted in 1947. Y adopted in 1963. These are the adoption deeds. Where is the pleading first? Let alone evidence. In the absence of pleading, any amount of evidence. Pleading, sir. If you say that adoption is as per your family custom or tribal custom, for that pleadings have to be taken up. In our community, there is a custom of taking the adoption, children in adoption, and for that, this is the procedure.
The giving taking is there. That is there in reading.
Giving and taking, your case is not giving and taking. Your case is as per the special custom of the community. Your case is not the adoption in Shastric sense, because you have pleaded as per the special custom obtaining in the community. Therefore, for that pleadings have to happen, for that evidence has to be laid. Now, yes,
you will also permit me to read from his DW1 question.
What the DW1 stated.
DW para 5 questions. Bhogan Behra, the
sold the property.
Sold the property and he claimed to adoptive father, but has not executed a document in my favor regarding my adoption or acknowledging my adoption. I have read up to class 10 at G High School, Belagunta. In my school record, I have been described as son of Natrutsava Patra, the natural father. In voter list, I have been described as son of Natrutsava Patra. Surat Patra is my natural father. He died in the year 1992. It is a fact that I am party in the registered document dated 12/4/94 executed by myself and my widow minor sons of my deceased brother. The document that he has that was executed, Salid was executed between the family, and there he was described as the son of his natural father. 94 was just 1 year prior to the.
Those sale deeds are of which year?
94 and present disputed sale deed 95.
Date, kindly give the date and which are the.
That is not on record.
Sale deed nahi.
No. It is you have admitted in the question. It is a registered document of 1281 dated 12/4/92 executed by myself and my widow. He has himself executed the sale deed. Sorry, madam.
Date
12/4/94.
12/4/94 sale deed.
No, it is a registered document, not sale deed. It is a registered document. What kind of document I do not know. It was realized by them, but it was not filed. But he had admitted that in the document, minor sons of deceased brother, in respect to property of my
natural parent's name is mentioned there. Yes, nowhere it is stated.
This was in
1994.
1994.
But adoption 1974.
74. And he admitted that in the said registered deed, I have been mentioned myself as son of Natrutsava Patra. There was
no adoption deed.
No, that's all right.
That natural parent's name continued.
No, that's not your. That's your argument. He should have said. Your client should have said.
Yes.
Since there is no adoption deed, it's adoption
that is the pleading. That is the pleading.
And evidence again.
Yes.
If a will permit me to read further.
That is
If permitted one sentence, none of the neighbors of Bhagavan Behera, none of our castemen were present at the time of my adoption. There is no priest at the time of adoption ceremony.
But in your pleadings, you said street people were, relatives were there.
Right.
And now in your evidence, he admits that nobody was there at the time of adoption.
That is the reason why
the cross-examination your client has admitted.
2 to 7, they have not stated anything about the adoption.
He is the only person who spoke about the adoption.
The only person who was 15 years old.
But no case for it. No case for it.
There are further
That question can be gone into by the lower appellate court of facts.
No. Question
is a question of fact.
Question of fact is true.
Yes.
But the questions which
I will get a forum. I will get a forum. I will use a forum.
For providing a sense. Sir, my point is,
yes.
See,
I will get a forum.
I very humbly say that I am good in civil law. In other law, I am not that good. In civil law, I am good because I was a teacher.
Well, also I appreciate the prejudice.
Where is the adoption? If we were adopted, then question arises.
Let the matter be remitted.
No. What for remitted?
For decision. You also fix a date.
Absolutely.
Time limit.
No, yes.
Time frame will be there.
No, how justice will be done? Firstly, you say adoption was as per the...
Because I have not been given an opportunity.
No, you are giving an opportunity now.
To address an adoption.
It's not question of, it's not jurisdiction.
And here,
already relapsed in meantime.
And there is no prayer for declaration of title. Title is being disputed by the defendants.
Who are you?
Pardon me?
Who are you to
dispute the... I'm the heir, legal heir.
Unless that
seller
is established.
Seller is dead.
Unless the adoption
and I will get the property.
No, sir.
If the sale deed is arranged, then I will get the property. I will be entitled to the property.
Provided
I am the nephew.
Provided your adoption is proved.
No. Even adoption is not proved. I am an heir because I am the nephew. Because the seller was issueless. Seller was issueless, had no issue.
Even without adoption, you would have been the class 2 heir under...
Yes, so brother, son, your lordship may appreciate. I am the legal heir. I will be entitled to the property.
Hindu Succession Act applies to scheduled tribes?
I am not a stranger.
Whether Hindu Succession Act applies to scheduled tribes, what's the law?
No.
In that section. No.
Hindu Succession Act doesn't apply.
Doesn't apply.
Hindu law will apply.
Huh?
Hindu law will apply.
Hindu law?
Yeah. Hindu law text will apply. Not Hindu Succession Act.
Hindu Succession will apply.
Section, which section?
Under Hindu law, I am a legal heir.
What?
Section 2 or 3. 2. Section 2, I think. Section 2, I think.
Section 2. Section 2, it is clear. But that doesn't apply.
Does not apply.
Yes.
If it does not apply,
Hindu law will apply.
Which is
Under Hindu law, Mithakira Hindu law, I am a legal heir.
Show that.
That I will show. I am not prepared now, right now. The Lord may keep it on Monday, I will show. I will show. Because I will show the text. I have not brought the text. If Lordship, if text is given, I will find out. And show. Hindu law.
Hindu law. Mullah Hindu law.
Yes, Mullah Hindu law. Mullah Hindu law.
Anyway, let him look.
That is the legal heir.
Because he wants...
Yes, no issue.
Not a case for...
That law also will not be applicable. If any law also will not be applicable,
not applicable.
Let him come.
Separate thing you have to show. This old matter is very reluctantly adjourned for further hearing in the second week of third week of January 2026 at the request of...
You will not grant inference stay. Otherwise,
I will be out of position.
I will be out of position. I will be thrown through the street.
You are
my dwelling house. It's my dwelling house. For that reason, I am insisting. Otherwise, I will not have.
No, nothing. There is no case at all. Even now, I am not convinced. You are saying that you want to show from Shastric law that even among scheduled tribes.
I am a legal heir.
You are a legal
heir of this is transparent.
According to you, even if adoption is not proved.
Yes.
Still,
I am a legal heir.
Provided but the trial court said sale deed is not proved.
Sale deed is not proved, but appellate court pending because all the attested witnesses have been examined. Consideration himself, plaintiff himself admitted, original seller, he himself admitted in the plaint that I have sold the property to so and so. The admission is there of the original seller. So all this theory that he was old building and all these things go to the wind because he himself, the original seller admits, and also not only that, the attested witnesses have also been examined. So it has been clearly proved.
Let us see.
It's a finding of fact now.
Next date of the calling the third week of January 2026 for the further hearing. Yes. Also say. Okay. So much time we spent now on this. Yes. Take one of all matters.
Weekly list item 36.
Just make a note on scheduled tribes and adoption law. Okay.
Item.
No, it's right. That is Datta Chandrika by Narayana Bhatta. Take out that text in this way. So there is a good book which you may look into. Datta Chandrika by Narayana Bhatta. Very old text which P.V. Karnal, History of Dharmashastra. On adoption, there is Datta Chandrika. Dattaka Chandrika by Narayana Bhatta. Just look into that. He says the Shastric Hindu law relating to adoption is not applicable to he uses the word Shudras. That's another thing. He says that way. So if your clients are scheduled tribes, then ordinarily they fit into that idea. Though I am against that particular idea, on the legal aspect I am saying.
Yes.
So I don't think that in lower Varnas, the adoption is recognized. Just look into and come back. Yeah.
Item 36. I take time. I have already received the draft Parawich comment. Only
36.
Yes.
Very short question.
The third week we'll call this. Third week of January at the request of the DGA, Mr. Lenka.
To file counter because that will not file counter. Last
Just in the meanwhile,
last
counter is maybe filed.
Madam, yes.
Filling which right to file on stand for fee.
Yes.
Madam.
Yeah.
Okay.
I have already received.
Yes.
Weekly list item 37.
The first week of February. Yeah.
Item 38, 39, 40 have been adjourned. Item 41.
Yeah, I don't think I am appearing on that book number in some
I am
items.
from the petitioner, my lord. My name is Sandharani Prani from BC Barampur, my lord.
My appearance will refer. I am for the
Agent. But at least now at least name should be name to be mentioned. Not
I am giving you
that. See, so appears for OP number
3 and 4, madam. Sub items.
List item 41.
Wait, please, wait. My lord, on the last occasion, I have been a case for regular service, my lord, and they are appointed on 2016, my lord, as per annexure 3, 27/5/2016. Till today, the service not regularized.
not your matter. This is serial number
41.
41.
My lord, on the last occasion, I handed over one similar judgment asked by your lordship to my learned.
Yes, that is covered by judgment.
Yes.
Which is that judgment? Give me copy.
Yes, I have. It has been corrected.
You have printed everything.
Fair copy. This is a fair copy. Is the fair copy?
Fair copy.
Yes.
As per this to be printed.
Yes, my lord. Only the date of regulation, similar situated employees. my lord. They have been regularized with effect from 27/11/2000.
You have, by your hand, you have changed this.
Yes, my lord.
That you have printed there.
Yes,
And
my
this
lord.
is to be done this way.
Yes, my lord, this way. Because for a fair copy to hand it over, my lord, for that is.
Make that.
In this case, my lord, of Mr. Dayananda Mahapatra, senior advocate may be recorded by.
Who appears, his name we can record. Unless senior advocate appears.
My lord,
How can I record?
His power
Can I
is-
record something false? And everything is online. But whoever is here, you argued that's my Yeah.
We finished item 42.
Is it eating my law? After the grant of pension and pension, in the pendency of the occasion, petitioner is that it is time to file substitution.
Petitioner having died, counsel seeks time to file a substitution application in the place of the deceased. Call in the first week of February. Have it. Yes.
Item 43.
Yes, my lord. Petitioner was appointed as a junior clerk way back in 1986 and 82.
Date.
We are junior clerk 7. He was appointed junior clerk on 2/7/76. Annexure 1. 276. While continuing as junior clerk, he was on suspension on 11/6/82.
11/6/82 suspended.
Suspended. He was reinstated service in the 1991.
Give the date.
Date,
Unless
madam.
you give date, I
Yes,
cannot record
yes.
anything.
29/90/95, Annexure 3, page 19.
20
September 95. Annexure 3, page 19.
What is that order? Suspension revoked and you are reinstated in service.
Yes.
Suspension was in 82.
11/6/82.
Revoked in 91. 5/91.
And reinstated in 91.
91.
11, 10 and
In
91.
the entire period, suspension treated as duty. By order dated September 95.
What is that order?
Directing the period suspension as a duty.
That whole period.
The whole period.
Annexure 3.
Annexure 3, page 19. ma'am. Thereafter, Annexure 5, salary has been paid for the entire period.
They have paid the salary of
Page 21.
24/9/97.
24/97. Page 21. But what happened? Thereafter, I was not allowed to discharge my duty, for which Annexure page I after the then Inspector of Schools, Hon'Ble, now DU Kandhamal, OP number 2, OP number 3.
Yes.
Based Annexure 7, I requested for my release of my reinstatement. They directed the OP number 3, direct OP number 4 for an inquiry. What happened thereafter? The collector dated 20th March 2001 directed the collector, the DO to examine the matter regarding pension. But I am not allowed in pension. I applied on tribunal.
Tribunal under Annex 9, page 27, directed to consider my case. Because by the time I attended superannuation, but they are not giving the pension, tribunal directed to consider my case. Now tribunal directed to examine the case and take a decision. But thereafter, nothing has happened. I approached the inspector schools under Annex 10, directed to consider my grievance to OP number 4. But ultimately, I approached minor again for grant of pension. Minor directed to examine the case of petitioner under Annex 11. That is minor directed coordinate bench order.
Mr. Murthy, one thing. 2776 he got entry. And 11682 suspension.
Yes.
111091 revocation of suspension. 20 September 95, you treated the entire period of suspension as duty and you have paid the salary also. Then with effect from which date you terminated this service?
I'm coming now.
Yes.
Let them submit.
They only this much.
This is half of the story, my lord. This is half of the story. I'm considering to the fact he has been reinstated on 11/10/1991.
Correct.
Joined in 5/11/1991. Undisputedly.
Yes.
After joining on 27/9/1994, detained in NSA.
National Security Act.
Yes, ma'am. Kind of a glance, it has been reflected in Annex 9, page 27 for a moment. It's a judicial order.
Annex 9. It's a tribunal order.
Again.
Annex 8.
9. 36, page 36.
It is an order on tribunal.
Nothing in Annex 9.
It's not an order tribunal, which I approved.
Which annex are you are referring to?
Page 27.
OA number 1299.
1299.
In that, where is that observation?
But in the third para, he was placed under suspension pending trial of the departmental proceeding on his detention under the National Security Act by the Annexure 2 from 4/5/1994.
4/5/1994. True. What happened to that case?
My lord, thereafter, he was put under suspension again. My lord, point out that date, my lord. 25/4/1994. 24/4/1994. 1 second. While the matter stood thus, he has tendered his resignation on 11th August 1994.
11/8/94.
11th August.
Resigned.
Yes, ma'am.
Where is the resignation acceptance letter?
Yes. That, my lord, they have not annexed, my lord.
No, you should.
That because I have not filed the counter and I have got the PwC, my lord, enter for that. And thereafter, he has withdrawn his resignation before acceptance and after communication.
Before acceptance means? It was not accepted.
It was accepted.
After acceptance, he withdrew that.
Yes. I'm also pointing out.
He applied for withdrawal.
Yes, ma'am.
Did you permit withdrawal?
No, my lord. By that time, it was already accepted and communicated.
That was resignation was accepted on which date?
The resignation was accepted on, my lord. It was withdrawn on 8/10/1994.
11/8/94 is the date of resignation according to you.
Yes.
It is resignation letter.
Resignation letter.
Yes. When did you accept resignation? A resignation takes effect unless he is a constitutional authority.
Yes, ma'am.
It takes effect when resignation is accepted.
Accepted.
Therefore, acceptance you have to show. In case of constitutional authority like judges of High Court and Supreme Court, if we send letter, it is resignation. It need not be accepted.
But in other case, you have to act upon the same. Act upon the same. My lord, for that,
Sudhindra Rao versus Pollution Control Board.
So notice was issued, Miller. This was not accepted and refused by the petitioner concerned. Then it was published in the Delhi newspaper Samaj, Miller.
Acceptance.
Yes, Miller.
No, if you have accepted sufficient, it need not become
No,
acceptance.
it's a
need not
communication
become-
because
you have communicated also.
Communicated also because otherwise it will not be sufficient, Miller.
You communicated it when it was published in Gazette.
It was in the Samaj newspaper, Miller, Samaj publication.
Was it notified in the Gazette?
No, Miller, it did not get. It
The
is
newspaper-
widely circulated Odia Delhi, Miller. The premier one is Samaj, Miller.
Date of which date?
Miller, date and 24/11.
This is paragraph 16, everything I have discussed. I mentioned, my lord. My resignation was sent by the SP Kandava to the D office.
Yeah?
My resignation was sent by the SP Kandava, Superintendent of Police, to the office of the DO. I have never summoned a resignation. There is a specific stand, paragraph 16. I was a political leader, the local leader of that area.
You?
I was.
How could you be local leader if you were an employee?
No, local leader in the Control community. Control community, I was the leader.
What happened to that National Security Act case?
That immediately.
Where is that order?
That there, I was on this. There they mentioned in the same order they mentioned. Kindly see annexure 8.
You file a counter.
Yes, ma'am. I have got that here, but details.
No, counter is necessary in this matter.
I'll file it.
Call this matter in the first week of February 2026. In the meanwhile, counter if any may be filed, failing which.
Correct.
You face item 44? Tara? Read. Just look into that judgment of Sudhindra. View that citation, please. Yes. Yes.
But this case is virtually covered by your lordship's judgment that is relating to special bid. Here, my lord, the petitioner applied for the post of trained graduate teacher.
It's a purpose to Delhi judgment.
Yes. My lord, an advertisement was floated by the director, secondary education.
Come to the point that
Yes.
where is that
My lord,
brother, we have held special B.Ed is equivalent to general B.Ed.
and I have also brought another
So
judgment.
yesterday also we have held, no? That
Yes. I was arguing, and another judgment of Rajasthan High Court. Will also may kindly take note of that.
Delhi High Court
held
it
has-
because
has taken.
of the affidavit of the chairman of that commission.
Yes.
But in Utkal University, so far this bid equivalent to special education in Utkal University.
My lord, may kindly see that judgment. Rajasthan High Court judgment, para 7.
B.Ed special, flying degree. He had also studied papers pertaining to B.Ed general course. Petitioner to be eligible for post of teacher, grade 3. Do you have yesterday's, which is that judgment?
Yes.
Yesterday we have passed that
Yesterday,
judgment.
my lord, that judgment has not been uploaded.
32.
That is item number 52.
But they have relied upon that judgment of that Bhopal.
No, this court has held already. I have held that way. I followed Delhi judgment. I did not know Rajasthan High Court, but Delhi judgment I followed. He only had argued that matter.
And my lords, Onakar's one.
Onakar's one.
Yes.
I have that judgment.
And in addition to that, this is Rajasthan High Court judgment. Para 7.
But you were not selected only
on that ground.
Where is that order?
Our ground is he has not possessed that training qualification of
B.Ed in special education. Your lordship may kindly come to Annexure 30, the impugned order.
Annexure 13.
Annexure 30, page 85. I was selected against PWD categories. My lord, may kindly come to Annexure 13 at page 85. It starts from page 85. My lord, may kindly come to para 5. 86.
That there is nowhere mentioned in the
aforesaid advertisement regarding equivalence degree of bachelor's in education, B.Ed, for the post of TGT Arts. Moreover, in respect of high school teaching post, the special education B.Ed has not been accepted as equivalent to general B.Ed course.
Next paragraph, what is that? Paragraph 5.3.
Paragraph 5.
In para 6.
Para 6, that it is clear that the petitioner is not eligible for the post of initial appointee TGT Arts as per condition enshrined in para 5.B of the advertisement dated 23.
What is that? What
yes,
is that?
You also may kindly say Annexure 1. Annexure 1.
Page 16.
Page 16. It starts from page 16. My lord, may kindly come to page 17. Para 5B. B. TGT Arts, same perimetria qualification. Bachelor degree in Arts, Public Commerce or a Sanskrit degree from a recognized university with 2 school subjects. School subjects are defined in the proviso hereunder. From a recognized university having 50% marks in aggregate, 45% for SC, ST, PWD, SCVC candidates, and Bachelor in Education, B.Ed. Then stroke 3-year integrated B.Ed, M.Ed from an NCT recognized institution. Same perimetria, my lord has decided.
6 grounds have been given by the impugned order.
Yes.
Let us see one by one.
One by one, yes.
All they relate to this one only?
Yes.
Go to impugned order.
Yes, para 30, Annexure 30. It starts from 85.
You also
that the petitioner
and accordingly this will be to secondary education examine the representatives and dispose of the same in the following manner.
Yes.
The petitioner has especially include his name in the merit list and appointment for the post of initial appointment. 1 and 2 are facts, sir.
Yes.
3 that as per
3 is the qualification quoted.
5G.
Yes. 4, I have passed special B.Ed from Madhya Pradesh Bhoj Open University, Bhopal.
Then squarely covered by the judge.
Squarely covered, and you will also may kindly see NCT.
Yesterday's judgment.
Yes.
So we have considered NCT. Is it recognized by NCT?
Yes, I have given that. My lord, may kindly come to Annexure 11.
Which is that serial number, yesterday's number?
My lord, yesterday 32. That advertisement was floated by the Staff Selection Commission, here by the Director Secondary Education. This is the only difference. And you also may kindly see my scorecard. I am a PWD candidate. And so far as PWD candidates are concerned, my lord, may kindly see the advertisement. 33 posts were earmarked.
Yesterday they were 46.
Yes, 46. That is page 29 of the advertisement. TGT Arts, I belong to VI category, visually impaired, 33. And out of 33, only 26 posts have been filled up, 7 posts are left, according to me. And
Mr. Monty, I have held that
66 minutes.
Ankar Swing.
No, Ankar Swing. This is for yesterday.
Yesterday judgment.
And yesterday I had identical question I have answered. In the light of Delhi judgment.
Yes.
Delhi judgment we followed in Ankar Swing. And in yesterday, both these judgments I considered and held that B.Ed special answers the requirement of B.Ed.
That is from IGNOU.
That was from IGNOU.
Here Madhya Pradesh Bhoj Open University. That is also recognized by
NCT.
NCT. I have given that.
It's covered by judgment.
But in our university, so far the B.Ed is concerned and it complies the advertisement also. So far the advertisement is concerned and bachelor degree in education, oblique 3 years degree.
Bachelor's degree in education.
Even
at the instance of IGNOU. special bachelor's degree, that B.Ed, is treated as B.Ed general of any university, provided that course is recognized by NCTE Act by the NCTE under the NCTE Act 1993.
But we are only on that ground that having no B.Ed qualification and having no training qualification.
No,
but the purpose in person to the advertisement.
And annexed
Tell the date of advertisement.
well, the date of advertisement is 23/12/2021.
Page 16.
Page 16.
Petitioner who was in the fray of selection for the post of
TGT Arts. But the nomenclature of those posts are initial appointee teachers.
That is, with the nomenclature of initial appointee teacher, having been decandidatured on the ground that his B.Ed special qualification does not satisfy the B.Ed general qualification prescribed by the advertisement dated 23/12/2021
under clause 5B.
at Annexure 1.
Yes.
More particularly, clause 5, capital B.
Yes.
First term. Next paragraph. Learned counsel for the petitioner submits that the question of equivalence of B.Ed special to B.Ed general is no longer res integra.
Yes.
In view of decision of this court in WPC number 16508 of 2024 between Anakar Swain versus State of Odisha, disposed of by this court, white judgment dated 28/10/2025.
And yesterday.
He also presses into service the judgment of this court in serial number
32, WPC number 37449 of 2020.
The judgment of this court in WPC number
37449 of 2023.
Disposed of by this court, wide order dated 18.
32. Main list or 32?
Weekly list. First.
Weekly list or 32?
Next paragraph. Learned HA appearing for the OPs vehemently opposes the petition, contending that the educational qualification is specifically prescribed in the advertisement in question, and the authorities, having examined all aspects of the matter, have come to a fair decision that the petitioner does not answer the requirement. Petitioner's qualification does not answer the prescribed qualification. First one. Next paragraph. Having heard the counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter, broadly agreeing with the submission of the counsel for the petitioner. So that the question is no longer res integra. First up. This court in Anakar Anakar Spain Subra
and Samarendra Panda. Day before yesterday's case.
Day before yesterday?
Day before yesterday. Item 32 of the weekly list. And you will also kindly take note of this Rajasthan judgment also. Para 7.
Yeah. Has specifically held that B.Ed special secured by a candidate in a course recognized by NCTE would be equivalent to B.Ed General.
Yes.
General. First time. That being the position, contra contention of the learned AGA does not merit acceptance. First time. Next paragraph. There is another aspect to the matter. Colon. Petitioner is a PWD candidate.
Yes.
Having, is he blind or what?
Blind.
Yes.
Having vision impairment.
Visioning impairment.
Vision impairment. First one. 23 votes have been earmarked for PWD candidates.
No, only for VI. Total is 132 out of 132 meant for reserved category candidates, PWD.
The PWD candidates. Of them,
33 is for VI.
Vision impairment.
Yes.
Visual.
All 33.
All 33. Out of 132, 33 for VI.
33 have been reserved for vision impairment candidates.
Yes.
First one.
And 26 posts.
Council submits that only 26 have been filled up.
Yes.
Leaving 7 continue to be vacant. In considering claim of the candidates of the kind, the state should be a bit lenient so that the parliamentary purpose enacted in the 2017 Act, which is the latest
2017 Act, 16 Act.
What is that?
The Disability Act 2016.
Disabilities Act 2016. Before this paragraph, one more paragraph in between you have to put. Learned counsel for the petitioner also rightly banks upon the decision of Rajasthan High Court
Para 7.
In
Para 7.
Para 7.
In what is this?
Beard. Lordship may kindly say Para 7.
No, that's not. What is the citation?
Citation is
neutral citation also can be. They are online it is.
Yes.
No, 2003, yes. 2003 level, I see. 1791, 2003 SCT, page 736.
Rajendra Singh Shekhawat versus State of Rajasthan, 2003, Lab IC, Labor and Industrial Cases, Lab IC 1791, wherein paragraph 7 reads as under. Yes. In the above circumstances, this petition succeeds. Semicolon. A writ of certiorari issues quashing the impugned order dated 11/5/2023 at Annexure 13.
Page 85.
First, a writ of mandamus issues to OP number 2 to consider candidature of the petitioner
for appointment because he has
went to the post of
trained graduate teacher
in arts within a period of 8 weeks if he is otherwise eligible.
Yes. But he has secured 82.9450915 marks in CBT test, Annexure 5.
One sentence you
computer based test.
They will add one more. Petitioner has secured
82.66, 82.945 0915
5095
915
915
marks in computer based test
9450
915
as is reflected in
Annexure 5 at page
Annexure
66.
issued by Directorate of Secondary Education.
Yes.
First, thus apparently, with all impairment, he is absolutely meritorious. Okay. At that, show me that afterwards. No cause.
Item 45.
The petitioner who was engaged as a secretary.
We have one function and one meeting.
Second week of January. Second week of January.
Manual counter has been already filed.
Your file counter?
Counter result everything.
Item 37, I was sought for possibility in February. The poor man have retired. It's for regulation. My senior is there. It's called the Board of Secondary. But 37. Second week of January.
Second week of
Yes, Mr. Ram.
Let's make it third week.
Third week.
Because second week is same prayer, my lord.
47.
47, same prayer.
47.
Item 46. 48, my lord. Well, this date of birth issue has been covered by your lordship judgment in Prithviraj Naik. Let it come, my lord seniors there. I have also solved the copy.
The second week of January.
48.
46 item.
Item
after vacation.
Urgency.
My lord,
No, after vacation.
I am for the petitioners, my lord, for in item 46. Was it, I am for the petitions, my lord.
Application.
After vacation.
This is also a matter relating to B.Ed under challenge.
No, it is different than the present case.
Not same.
Not same.
B.Ed special and B.Ed general.
No.
This is
It is different.
Absolutely. B.Ed.
Fine.
But not this.
Not
Item 142. Item 142. The man retired in March 2026. Only 3 months left. Proceeding is still continuing, not disposed. Therefore, I print second week of January in the immediate letter file counter also.
If we put second week of
Because of urgency.
Other judges, he will come to my chamber.
Kind enough to take out the matter. Well, fix it then. January. Counter file in the meantime.
Item 78 is taken after vacation.
After vacation. All other rest of the matters after vacation.
Okay.